Hello, good morning, and welcome to Byjus Exam Prep. Yesterday, we discussed some of the important concepts related to the Union Legislature. We discussed various offices, for example, the Speaker, Deputy Chairperson. We discussed Leader of the House, Leader of the Opposition, Whip. Then we also looked at what is an ordinary bill towards the end of this lecture. Today, let's start with what are the powers, privileges of the parliament and the members thereof. So there are some powers, privileges, immunities which are available to the members of the parliament as individuals and then parliament as an institution. What are these privileges? There shall be freedom of speech in parliament. Constitution originally said there should be a law passed by the parliament which would define what are these privileges and immunities that are available to the members of the parliament and that should be available to parliament as an institution. But till the time this law is passed, all the immunities and privileges that are available to British Parliament and its MPs, those will be applicable in India as well. What is there in the Constitution? That there should be immunities, privileges for the members of the Parliament and for Parliament as an institution. What are these immunities and privileges basically? So that members of the Parliament can discuss all the issues of their constituencies, all the problems that are plaguing our society without any threat that whatever I say in the Parliament, somebody can file a case in the court. Because with this assumption, then you will not be able to fearlessly defend your constituency. Not just that, other organs of the state should not interfere in the functioning of the parliament. Just like parliament does not interfere with the functioning of the Supreme Court. In a sense, when do they take up a case? How many judges should hear a particular case? Why this particular judge is hearing this case? Why not someone else? All the three organs should be able to perform their own tasks. For that, the Constitution said Parliament should enact a law so that this law can talk about various immunities and privileges that are available to Parliament as an institution and its parliamentarians as individuals. But till the time Parliament frames such a law, it might take some time, but till the time Parliament frames such a law, all the immunities and privileges that are available to the British Parliament and its MPs, those will continue in India. That means no separate privilege for Indian Parliament or its members, but all those immunities and privileges which are available to British Parliament and their MPs, that will be applicable in India as well. Then the year was 1978. "44th Constitutional Amendment Act." Parliament amended this provision of the Constitution and said all the privileges and immunities that were applicable prior to this amendment shall continue. Now listen to me carefully. For example, this is 26th Jan 1950. Are there immunities and privileges available to Parliament and MPs? Yes. Which are these privileges? Those which are applicable to British Parliament and its MPs. Clear? continues, and now we reach 44th Constitutional Amendment Act 1978. This law came into force on 20th of June 1979. But that date is not important. What is important is when this amendment was passed, this amendment said all the privileges and immunities that were applicable prior to this amendment, those will continue. What were the powers, immunities, privileges applicable to Indian Parliament and its MPs before this amendment? British privileges. The same privileges will continue after this amendment as well. So what changes? Nothing. Then what changes? When this bill was introduced in the Parliament, it was for a reason. The reason was the minister said, why should an Indian constitution refer to British Parliament? We are an independent country now. We are a sovereign country now. We are a republic. Why should our constitution explicitly mention something related to our colonial past, something related to the British government? We should drop this word British. That means in reality, nothing changes. The only thing that changes is that Indian constitution's reference to British Parliament and its MPs, that reference has been dropped. Otherwise, same privileges, same immunities, which are applicable to the British Parliament and its MPs, those privileges continue. And this law, which the Constitution envisaged, imagined that Parliament will pass, so that this parliamentary law will codify all the immunities and privileges that are available to the members of the Parliament. This law is yet to be passed. Which means the same British parliamentary privileges continue in India as well. But what are these privileges? Constitution explicitly says there shall be freedom of speech in the Parliament. Now, what is this freedom of speech? As an individual citizen of India, you, me, all of us, we have freedom of speech under Article 19, Clause 1 of the Constitution. But this freedom of speech is not absolute. There are 8 reasonable restrictions on your freedom of speech and expression. But when we say freedom of speech, for MPs, for legislators, and this is true not only for the members of the Parliament, this is true for the members of the state legislature as well. MLAs, MLCs, MPs of Lok Sabha and Rajya Sabha, they have the freedom of speech. When we say they have the freedom of speech, this freedom of speech is different from the freedom of speech mentioned under Article 19(1)(a) of the Constitution, where there are 8 reasonable restrictions. There is no restriction on the freedom of speech of parliamentarians inside the Parliament. This freedom is absolute. They have absolutely no restriction, no limitation on their exercise of freedom of speech inside the Parliament. Inside the Parliament, they can say anything. Why? Because this is the privilege available to the British parliamentarians as well. Why? Because the assumption is, if I am able to speak freely inside the Parliament, if I am able to speak my mind, my thoughts within the Parliament, only then I can become a better representative of my people. Only then can I make better laws for the welfare of this country. Constitution further said, no member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the Parliament or any committee thereof, and no person shall be liable in respect of publication by or under the authority of either House of the Parliament of any report, paper, votes, or proceedings. What does that mean? There are two things now. Listen to me carefully. When we say members of the parliament, they have an absolute freedom of speech inside the parliament. They can say whatever they want to say, but that is subject to the rules of parliament. Sir, but inside parliament, when some member speaks something, the chairman or the speaker says, this will not go on record, this will be expunged. No, why are you saying this? You have to apologize. Something was recently said by one MP of the BJP, referring to another MP belonging to a minority community, that you are a terrorist. And now this matter is to be dealt by a committee of the parliament. If they have an absolute freedom of speech and expression, then why action is taken against legislators? If whatever vote is given inside the parliament or whatever is said by the parliamentarians, no action can be taken against them, why is action being taken against Mahua Moitra? Because she has said something, she has asked certain questions in the parliament. For that, you need to understand, no member of the parliament shall be liable to any proceedings in any court. That means whatever you say inside the parliament or the way you vote inside the parliament, you cannot be held accountable in any court of law. That means the courts in this country cannot punish you. No matter what you say, the courts cannot punish you. That is why sometime in the past, Mr. Rahul Gandhi said, I have details of personal corruption against Mr. Modi. But Mr. Modi is afraid of me. He is not letting me speak inside the parliament. Let him allow me to speak inside the parliament. I will tell the nation on the floor of the parliament the details of personal corruption against Mr. Modi. Now, there are individuals who may call him Papu or somebody who is not too talented or too smart, but he's very smart. He knows whatever he says inside the parliament, no action can be taken against him in any court of law. Why? Because inside the parliament, you enjoy absolute freedom of speech and expression. That means although your freedom of speech and expression outside the parliament is restricted on the grounds of defamation. If you defame me, I will drag you to the court. If Mr. Rahul Gandhi defames Mr. Modi outside the parliament, Mr. Modi can drag him to the court. But inside the parliament, no matter what Mr. Rahul Gandhi tells, whatever he says, even if it is defamatory in content, no action can be taken against Rahul Gandhi in the court of law. But that doesn't mean no action will be taken against him, because this freedom of speech and expression is subject to the rules of the parliament, the rules of business and procedure of the parliament, where you can't use derogatory language, where you can't refer to somebody who is not present in the house, where you have to speak to the chair and not to each other, where you can't use inflammatory voices inside the parliament. But no action can be taken against you in any court of law. Action can be taken by the parliament itself. So parliament itself has the power. That is the immunity. That is the privilege of the parliament. Parliament can punish its own members if they have violated the rules. But the courts cannot interfere. Why? Because this is the practice that is prevalent in Britain. This is the practice which is now prevalent in India as well. No matter what you say and how you vote inside the parliament or any of the parliamentary committee, no action can be taken against you in any court of law. And this came to one extreme. The year was 1993. In 1991 elections, Congress emerged as the single largest party. Mr. P.V. Narasimha Rao became the Prime Minister. Now in 1993, CPIM, which was in the opposition, the Communist Party of India, Marxist, it introduced a no confidence motion against the Prime Minister. No confidence motion we will discuss today. It's basically a tool employed by the opposition to test whether the government has the majority or not. No confidence motion, when it is introduced in the parliament, there is a discussion on this no confidence motion, and ultimately there is voting. If this no confidence motion is passed by simple majority, that means the Lok Sabha has passed a resolution saying we do not have the confidence in the Prime Minister. When we don't have the confidence in the Prime Minister has to resign. Because Prime Minister and his Council of Ministers, they are responsible to Lok Sabha. They are accountable to Lok Sabha. So now Communist Party of India, Marxist, introduced a no confidence motion against P.V. Narasimha Rao. P.V. Narasimha Rao did not have the absolute majority. But somehow he won this vote. He defeated this no confidence motion and he survived as the Prime Minister. Later on, few newspapers carried out articles saying bribes were given. Some MPs were given bribes, and in exchange of those bribes, these MPs voted in favor of P.V. Narasimha Rao. That is how he survived. Matter later went to the Central Bureau of Investigation. CBI conducted the investigation and ultimately presented the report before the court. The court asked CBI, what are the details of this case? CBI said that we have information that 10 MPs took bribe to vote. 10 MPs took bribe to vote in favor of P.V. Narasimha Rao. That is how he survived. The court asked, give us more details. CBI said, we don't have enough details about 5 other MPs, but for 5 MPs, we are sure that we have the proof that money had exchanged hands and that is how they voted in favor of the government. The court said, give us more details. CBI said, out of these 5 MPs, 4 MPs voted, 1 MP abstained. The principal question before the court was, are these members of the parliament public servants? If they are public servants, that means then Prevention of Corruption Act is applicable. Because if an IAS officer, if a state civil service officer, if any government employee is found taking bribe, it is a corrupt practice. And under the Prevention of the Corruption Act, you can be arrested, you can be prosecuted as well. Now, the question before the court was, are these members of the parliament also public servants? If they are public servants, then Prevention of Corruption Act would be applicable on them. Then on the allegations of bribery, we can prosecute them. The court said, yes, they are public servants. That means Prevention of Corruption Act is applicable on them. When it is applicable on them, now we have to see whether we can prosecute them. Court was told that 4 MPs voted in favor of P.V. Narasimha Rao, which means they voted against the no confidence motion, and 1 MP abstained. Court said, don't take any action against these 4 MPs, but let's prosecute this individual. 4 MPs who took bribe and voted in favor of P.V. Narasimha Rao, we won't take any action against them. But 1 MP who took bribe but did not vote, abstained, prosecute that MP. Why? Because they have an immunity. No member of the parliament shall be liable to any court in respect of any vote given. So if these 4 MPs took bribe, but for what? To vote in favor of P.V. Narasimha Rao. For this voting, we cannot prosecute him. But this 1 MP who took money but did not vote. So he did not vote, which basically means he only took bribe. So for taking bribe, we will prosecute him and sentence him to jail. This judgment has been criticized heavily. And after more than 2 decades now, recently Supreme Court has said we will revisit this judgment. This is considered to be the black spot on Indian judiciary. This is when bribery was institutionalized by the Supreme Court, saying you can take money to ask questions inside the parliament. You can take money to vote inside the parliament, and no action can be taken against you in any court of law. Which means even if it is found to be correct that Miss Mahua Moitra took money from an industrialist, and for that money she decided to ask questions inside the parliament on Mr. Adani or any other individual, for this particular act, Mahua Moitra cannot be prosecuted in any court of law. That means she cannot be sent to jail. She cannot be prosecuted in any court of law. But even this freedom of speech and expression is subject to the rules of the business and procedure of Lok Sabha. And for that, we have two committees. One is the Ethics Committee. The other is the Privileges Committee. What does that mean? Listen to me carefully. There should be immunities, privileges available to Parliament as an institution and its MPs as individuals. Done. For that, Parliament should enact a law. But this law has not been passed yet. That means, what are these powers, immunities, and privileges available to Parliament and its members? Same privileges which are available to British Parliament and its MPs. Clear? That's done. Now, what are these privileges which are available to British Parliament and its MPs? Number one, freedom of speech. No matter what these MPs say inside the Parliament or how they vote inside the Parliament, no action can be taken against them in any court of law. But action can be taken against them by the Parliament itself. And how action is taken? Listen to me carefully. You might have witnessed a scene where 4 police officers and a former IS officer, they were brought before Uttar Pradesh Legislative Assembly. And they were sentenced to 1 day to be kept within the Uttar Pradesh Assembly. So Uttar Pradesh Assembly was converted into a jail for them. How is that possible? Because these 4 policemen and 1 IS officer, many years ago, there was a member of the Legislative Assembly of Uttar Pradesh who had protested, and he was not allowed to protest. Basically, he was beaten. And ultimately, this member of the Legislative Assembly approached the legislature, approached the Speaker of the Legislative Assembly, saying, my privilege has been violated. And what is my privilege? I have to take care of my constituency. So just because I am the member of the Legislative Assembly, action was taken against me by the police. I was not allowed to protest. Parliament as an institution, legislature as an institution, it has the power to punish people for contempt. Just like Supreme Court or High Courts can punish people for contempt, in the same manner, Parliament and its MPs, if they are criticized so much that you are denigrating them, that is committing contempt, or that is what we call breach of privilege of Parliament, and action can be taken against you. Some time ago, 2 journalists from Karnataka wrote articles against the Legislative Assembly of Karnataka, against the members of the Karnataka Legislative Assembly. Action was taken against them. They were sentenced to 1 day in Karnataka Legislative Assembly. That was their punishment, because you have violated the privilege of the legislature. And for that, decisions are taken by either the Ethics Committee or the Privileges Committee. These committees of the Parliament, they are set up based on proportional representation system. Which means when this Mahua Moitra case is being handled by the Ethics Committee of the Parliament, she is alleging that Ethics Committee will be partial against me because the majority in this Ethics Committee is from the BJP. She may be right, but this is how it is. Members of these committees, they're appointed based on proportional representation system. So if there are 10 members or 15 members of the ethics committee, more than half of this committee will be from the BJP, because BJP has more than half of the strength in the Lok Sabha. Whatever is the proportion of your strength, those many representations you will have inside these ethics committee or privileges committee. But what is the difference? Most often, their jurisdictions overlap. That means most often they deal with the same thing. But we say ethics committee deals with matters which are of less severe nature, and privileges committee deals with matters which are of more severe nature. Now you might well ask, sir, give us the examples of what is this less severe nature, more severe nature. For example, once there was an MP who took his girlfriend or mistress by conveying that she's my wife. That matter was dealt by the ethics committee of the parliament. There was another matter when the member of the parliament took one lady and one child, but conveyed that, and this lady and this child, they traveled on the passport of this MP's own wife and child, which is a serious matter because it's violation of Passport Act. Ultimately, that matter was dealt by the privileges committee of the parliament. Long story short, although it involves breach of privilege, for example, whatever Mawa Moitra has done and what she has done allegedly, she has taken money from one businessman who is based in Dubai so that you can ask questions inside the parliament on Mr. Adani, so that Mr. Adani is defamed in the public, and ultimately this businessman will get the profit because they are the competitors. Mawa Moitra allegedly, it is argued that she said, I will benefit by personally targeting Prime Minister Modi. And what she did, according to the allegation, is that she gave the login credentials to this businessman in Dubai. What are these login credentials? That means recently there has been a change that you can ask questions inside the parliament as an MP by logging into a portal, add your username, password, login, and that is how you can ask questions, and these questions will go to the speaker. The credentials, the password and the login ID of Mawa Moitra was allegedly given to this businessman who accessed this portal from Dubai while Mawa Moitra was in India. And in Dubai, he is posting questions. And in return, some expensive gifts were given to Mawa Moitra, allegedly again. It is argued that LV bags and foreign trips, an expensive iPhone was given to Mawa Moitra. Whether it is correct or not, these are allegations. Don't hold me accountable for that. These are just allegations as of now. And now this matter will be dealt by the ethics committee. But this is a serious matter. This is a serious matter, and this should not have been dealt by the ethics committee. This should have been dealt by the privileges committee of the parliament. Because ethics committee normally deals with matters which are of less severe nature. For example, a member of parliament taking his mistress or girlfriend on a foreign tour. That's a less severe matter. But a more severe matter is when a member of the parliament took a woman and another child on the passport of his own wife and child, which is a violation of the Passport Act. Such a matter was dealt by the privileges committee. But whatever it is, ethics committee cannot punish, or for that matter, privileges committee also cannot punish. It can recommend. Ethics committee can recommend suspension, but privileges committee can recommend expulsion. Because ethics committee deal with matters of less severe nature, it can recommend suspension. That means you are suspended for 10 days, you are suspended for 1 month, you are suspended for one session of the parliament. But ethics committee can only recommend. Ultimately, it is for the house to decide. Whatever report will be presented by the ethics committee will be presented to the Lok Sabha, because Mahua Moitra is the member of the Lok Sabha. And now Lok Sabha as a whole will have to decide whether to accept this report or not, whether to accept this punishment, which is suspension of Mahua Moitra for 10 days or for 1 week or for one session of the parliament. But if this matter was dealt by the privileges committee of the parliament, privileges committee can recommend expulsion as well. You are expelled from the Lok Sabha. You will no longer be the member of the Lok Sabha. But privileges committee also will recommend whether action will be taken against Mahua Moitra or not, that the house will decide. But since in Lok Sabha we had the majority of the BJP, ultimately if the BJP wants, it can pass a resolution inside the Lok Sabha and Mahua Moitra can be expelled if this matter was dealt by the privileges committee. Can you challenge this expulsion or can you challenge this suspension from the parliament in a court of law? Yes, you can. But there are very thin chances of your success. For example, Mr. Raghav Chadha, he also approached the Supreme Court saying I was wrongly suspended by the parliament, by the Rajya Sabha. Although it has been accepted by the court, but I am not very keen, I'm not sure whether some benefit will be given to Raghav Chadha, because we have separation of powers. Separation of powers in the sense, the proceedings of the parliament are not subject to any court of law. The courts cannot interfere in the proceedings of the parliament. The court can interfere only if there is violation of principles of natural justice. Only if there is gross unconstitutionality. If there is grave injustice. On very thin grounds, you can get some protection by the judiciary. For example, if Ms. Mahua Moitra is expelled from the parliament by the privileges committee on the recommendations of the privileges committee, or she is suspended by the parliament on the recommendations of the ethics committee, can she file this petition in the court that she has been wrongly suspended? Yes. But on what grounds? When ethics committee, for example, one lawyer who made this allegation, who was considered to be partner of Mahua Moitra, and that is how Mahua Moitra called him a jilted ex, who is now leveling allegations against her. This lawyer and Mr. Dubey, the member of the BJP, who made these allegations, who wrote to the speaker, they will be called today by the ethics committee. And then after some days, Mahua Moitra ma'am can also be called, and she will be asked to explain her side of the story. She can also have her own lawyer to defend her. But if she is not allowed to defend herself, if she is not called and action is taken against them, it basically means the house has decided to punish Mahua Moitra ex parte without hearing her side of the story, which is violation of the principles of natural justice. You have to hear the other side of the story. After that, you can be prosecuted. After that, you can be sentenced. If she was not heard, she can approach the court. And the court will say, since she was not heard, now you hear this matter again. Hear this matter again, afresh, hear her side of the story, and then you can punish her. Otherwise, the courts will not interfere. If there is gross unconstitutionality, for example, if the parliament now says that ethics committee or privileges committee has submitted a report saying Mahua Moitra can never contest election again, she is barred from contesting elections for life. This is gross unconstitutionality. You can't do that. Under what law? Under what grounds? No, you can't do that. The courts will come to your rescue saying now you are expelled, now you are suspended, but you are allowed to contest elections later. Long story short, what is this power, privilege, immunity of parliament as an institution and its members? The first is freedom of speech. What is this freedom of speech? No matter what you say or how you vote, no action can be taken against you in any court of law. That is how these JMM members, because these 5 members were from Jharkhand Mukti Morcha, 4 were from JMM, 1 was from Janata Dal. No action was taken against these Jharkhand Mukti Morcha MPs. One of them was Shibu Soren, who is the head of the JMM. No action was taken against them because they took bribe to vote. So the court said there is a nexus between bribe and voting. If you're taking bribe to vote, if you're taking bribe to ask questions, no action can be taken against you in any court of law. But if you have taken bribe but you're not voting, action will be taken against you. Because for voting, how you vote, what you say, we cannot take any action against you. But this time, this one MP, he took bribe but did not vote. So we can prosecute him for taking bribe. If he would have voted, he would have been saved. Because he took bribe to vote in a certain manner. And how you vote, how you ask questions, what you speak inside parliament, no action can be taken against you in any court of law. But you can be prosecuted or you can be punished by the parliament itself if you have violated some rules. And these rules are rules of business and procedure. That is how, if you are creating ruckus inside the parliament, you can be suspended from the parliament. You can be suspended for a week. You can be suspended for the entire session. But this suspension is done by the parliament itself. This suspension is done by the speaker, not in any court of law. Now, let's say, for example, inside the parliament, a speech is given by Mr. Modi or a member of the government. And this speech basically talks about a defamatory content against, let's say, Robert Vadra, the son-in-law of Srimati Sonia Gandhi, the brother-in-law of Shri Rahul Gandhi. Let's say something is said by some BJP MP against Mr. Robert Vadra. Now, this is defamatory in content. Clear? So basically, you're accusing Robert Vadra of land grabbing. You got the land from the DLF. You got the land at cheap rates. Basically, it's defamatory. But where was it said? It was said inside the parliament. Now, under the directions of the parliament, under the authority of the parliament, if this report is published in a newspaper, if this report is published in the magazine, if this report is broadcast on Times Now or the Republic TV, will action be taken against Arnab Goswami for airing this content? Will action be taken against Indian Express for publishing this content? If it is done under the authority of the parliament, if the parliament has approved that yes, this report can be published, no action can be taken against them, even though this is not a matter within the parliament, this is now outside the parliament. Outside the parliament in the sense, no person shall also be liable in respect of any publication if it is by authority of the parliament or under the authority of the parliament of any report, paper, votes or proceedings. No action can be taken against them. That means they basically published the proceedings of the parliament. But if this proceedings of the parliament contains something defamatory, but if the parliament has approved, if the speaker has approved, you can publish this content, no action can be taken against you. That is freedom of speech. That is freedom to vote and say whatever you want to say inside the parliament, which is an absolute fundamental right inside the parliament. Something else. Freedom from arrest. What is this freedom from arrest? Let's say this is the session of the parliament. The session of the parliament begins, let's say 10th of November to 31st December. 40 days prior to the session, days after the session. During this entire period, You have freedom from arrest. A member of the parliament cannot be arrested. In civilian matters, does not apply in criminal or contempt of court cases. That means in criminal matters, you can be arrested even during the session. You can be dragged by your collar and arrested. But if it's a civilian matter, 40 days before the session of the parliament, 40 days after the session of the parliament, you cannot be arrested during this period. Why? Because this is the privilege available to British parliamentarians. Why privilege? Because the British Parliament assumes that the most important job and task of a legislator is to make laws. And laws are made during the session of the Parliament. So you have to prepare for that session. For that, we will give you 40 days. After the parliamentary session is over, you should also be given time to understand what was discussed inside the Parliament and prepare for the same. 40 days after the session. During this period, you cannot be arrested in a civil case. That is the immunity available to you. Immunity, for example, the Vienna Convention, which I told you when we discussed right to equality. For example, a diplomat who is posted in India, let's say a diplomat from Canada, he can commit murder, he can commit dacoity, no action can be taken against them because he enjoys immunity. That means do anything, but you cannot be arrested. But then you may be declared as persona non grata, and ultimately you will have to leave this country. If you don't leave this country, then you will lose your immunity, which means you can be arrested. To make immunity concept clear to you, you are hit by virus. Even then, you will not fall sick. Why? Because now you are immune to this virus. That's what vaccines are meant to do. The COVID-19 vaccines. When these vaccines are administered, the assumption is that you will build immunity so that tomorrow, if this virus is attacking you again, you won't fall sick because now you have attained and obtained immunity. Similarly, the immunity of the parliamentarian is 40 days prior, 40 days after the session. During this period, you cannot be arrested in a civilian matter. Why? Because the most important job of a legislator is legislative duty. Because who thought, and maybe the British Parliament would not have known that something would happen in Indian Parliament, that they would consider their most important duty to throw chairs at each other, microphone at each other, tear the copies of the bills, then use all the kinds of languages that we use. For example, somebody would have counseled you uh, if you are using some profanity, if you are using some abusive words, and somebody would counsel you and tell you, don't use unparliamentary language. Because parliamentary language is considered to be sophisticated, with full of dignity, decorum. Now I think we should change it and we should say if somebody is using abusive language, don't use parliamentary language. Instead, use unparliamentary language. In 2014, okay, we have to skip that example. And now, otherwise, it will be an overdose of examples. We will then lose the track of the syllabus. Second is freedom from jury service. What is this jury service? For example, I am witness in a particular case. I cannot be compelled to become a witness in a particular case while the session is going on. The session of the Indian Parliament is going on, but I'm also witness in a particular case. And the court is summoning me. You have to appear before us. If I don't appear before the court, what will court do? It will initiate contempt of court proceedings because I'm willfully disobeying a court order. But I'll say you can't take any action against me. Why? Because a parliamentary session is going on. I am the member of the parliament. I have to go there. I see beautiful chairs today. I have to throw them at each other. That is my job as a legislator. So while the session of the parliament is going on, you cannot be compelled from jury service. You cannot be compelled to become a witness in a particular case, to participate in the court proceedings. Why? Because this is the privilege available to British parliamentarians. This is the privilege available to Indian parliamentarians as well. So these are privileges which are available to parliamentarians as individuals. As individuals, you have freedom of speech. As individuals, you have freedom from jury service when the session of the parliament is going on. As individual MPs, you have the freedom from arrest. While the session is going on, 40 days before, 40 days after, you cannot be arrested in a civil case. But then parliament as an institution collectively enjoys some privilege. What is that collective privilege? It can exclude strangers from its proceedings and hold secret sittings to discuss some important matters. You might have witnessed, even if you haven't, I'll tell you what it is, that inside the parliament, there are people who can witness the proceedings of the parliament. So you can see the gallery where there are outsiders, where there are media personnel, where there may be representatives from foreign countries also. They may also be witnessing the proceedings of the parliament. But now inside the parliament, now we have to discuss something serious. Maybe we have to discuss what is happening along the line of actual control between India and China. Parliament as a collective has a privilege. And what is that privilege? All non-parliamentarians, you go out. Media, you go out. Sunset TV, you stop. Don't broadcast the proceedings of the parliament. Why? Because we are now in a secret sitting of the parliament. We are discussing a matter of importance, which we don't want outsiders to know, which we don't want even the citizens of this country to know. That is the privilege available to parliament as an institution. It can exclude strangers. Strangers are non-parliamentarians. It can exclude others from witnessing the proceedings of the parliament. That's the privilege. It can punish members as well as outsiders for contempt. 2011, India Against Corruption movement was launched by Shri Anna Hazare. And then Mr. Kejriwal, Mr. Manish Sisodia, Ms. Kiran Bedi, Mr. V.K. Singh, and various others, they also participated. Then Baba Ramdev also jumped in. Then film stars Amir Khan, Anupam Kher, and others, they also jumped in, and everybody spoke about corruption. They wanted Lokpal to pass. They wanted an institution known as Lokpal to pass so that Lokpal can punish even the Prime Minister, even the ministers. There should be an independent institution known as Lokpal who can accept complaints against the Prime Minister as well, against the ministers as well, against the IAS officers as well. That was the demand of India Against Corruption. And then Mr. Kejriwal gave a speech. He said, all these parliamentarians, they're corrupt. We have rapists inside the parliament. When we have corrupt people inside the parliament, you cannot expect an anti-corruption law to be passed by the parliament. And now there was a debate inside Lok Sabha on this. Very debate inside the parliament. Mr. Lalu Prasad Yadav got up. Lalu Prasad Yadav and Mr. Advani, Lal Krishna Advani, they were sworn enemies of each other. When Mr. Advani started Rath Yatra from Somnath temple in Odisha, this Rath Yatra, it was started to create awareness about the Ram Janmabhoomi movement, so that movement can be launched for the construction of a mega Ram temple at the then disputed site at Ayodhya. When this Rath Yatra entered Bihar, Lalu Prasad Yadav was the chief minister. He got Mr. Advani arrested. And at that time, Mr. Lalu Prasad Yadav became a hero. Arrested a very popular opposition leader, Mr. Advani. But then Lalu Prasad Yadav says, I took him in a chopper to a state guest house and then called him. Do you need anything? In his beautiful voice. Do you need anything? Is everything being taken care of? Whatever you need, you just let me know. I will take care of it. So even with arrest, he was treated with dignity. But then in one parliamentary debate, Lalu Prasad Yadav told Mr. Advani that you want to become the Prime Minister? Even I want to become the Prime Minister. but I will ensure that you will never realize your dream of becoming the prime minister because the country does not need you. You're this, you're that, blah, blah, blah. This was few years ago. And now in 2011, when Mr. Kejriwal is also leveling allegations against Mr. Advani, saying Mr. Advani is also corrupt, Lalu Prasad Yadav got up inside the parliament, inside Lok Sabha, and said, Advani ji ke baare mein aisi baat. Now Advani ji becomes a respectable man who is not corrupt, who is a senior leader of the Lok Sabha. So these individuals inside the parliament, they can attack each other, but they cannot accept someone from the outside attacking them. If someone from outside is attacking them, then they become a collective, and collectively you can punish these people. Why? Because they say inside parliament and as a collective, parliament as an institution has a privilege. Just like you can't say that the Supreme Court is a bunch of thieves. This judge gave this verdict because he is corrupt. In the same manner, you can't say that the parliament is consisting of thieves and rapists and the murderers. This way, people will lose faith in parliament as an institution. You can punish people for contempt. You can punish your own members for contempt if they have cast aspersions on parliament. That is the collective privilege available to parliament. Courts are prohibited to inquire into the proceedings of a house or its committees. There is something known as voice vote and vote by division. What is the difference between voice vote and voice by division? You might have witnessed a parliamentary proceeding wherein a bill is to be voted upon. And I am the presiding officer. I can be a speaker, I can be a deputy speaker, I can be from this panel of chairpersons. Those who are in favor of this bill may say A. Those who are against may say no. I think the A's have it, the bill is passed. That means I as the speaker, I as the presiding officer, I just ascertain through the voice whether on this particular bill there is a support in favor of this bill or there is a support against. Because if the voice says A is higher, which means more members are in favor of this bill. If no is slightly dim, which means less number of MPs are against this bill, I say the bill is passed through voice vote. And this was something which was meant to be for convenience. For convenience in a sense, let's say there is a bill, an ordinary bill to be passed in Lok Sabha. Ordinary bill requires what type of majority? Simple majority. Simple. But since I know the BJP has the simple majority in the Lok Sabha, they have more than 300 MPs. Their allies put together has close to 350 MPs. So if BJP is supporting this bill definitely will be passed. So for the sake of convenience, instead of asking all the members, you press your button and vote, it will be a time-consuming process. I take this matter through voice vote. Those who are in favor may say A. Those who are against may say no. I think the A's have it, the bill is passed. This was for convenience. But if I use voice vote, which is not mentioned in the Constitution, Constitution only says a bill is passed by both houses of the parliament if it has obtained majority. But it does not say that you have to judge majority through voice vote. But it is for convenience that the House has adopted this procedure that through voice vote we will decide whether a bill is passed or not. What if there is a member of the opposition who says, "Dear Speaker, I want division." What is division? That means not through voice vote, I want through division. What is through this division? That means now as the speaker I will say, let the gallery be cleared. That means inside Lok Sabha, no one else would be present, only the members of the Lok Sabha. I will say once this noise blinks, that is the time when you have to press your button. Either vote in favor, either vote against. And then after some time on the big screen in Parliament, you will have these numbers displayed. On this particular bill, 300 said yes, 120 said no, 80 said 80 abstained, 400 is the total. That means now we can say if 400 is the total, but 420 or 500 is the total, if 420, these are the members present and voting, more than half is 221. Since A's are more than 221, the bill is passed. If this is voiced by division, even if the opposition knows that on this particular bill we are losing, they may still insist on division. Said, no, I need division of vote. So that they cannot, so their intention is not only to find who voted in favor of them, their intention is to find who is against them. Their intention is to find who are these people who are neither supporting the BJP nor us. Who are these people who are abstaining? What if on a particular bill, the parliament decides, the speaker decides that we will not go for division? No, I will not accept division, I will go for voice vote. The bill is passed by both houses of the parliament through voice vote. Can on this ground, you can file a case before the court of law? No. Why? Because the courts are prohibited to inquire into the proceedings of a house or any of its committees. You can't do that. That's the privilege of parliament as an institution. If on a particular, for example, the 3 farm laws, they were passed through voice vote. On the grounds of this reason that the farm laws were passed through voice vote, could this be challenged in the court of law? No, because the courts are prohibited from inquiring into the proceedings of the parliament. Now, there is another collective privilege that parliament enjoys as an institution. For example, you committed murder. Is there any place in this world where you are safe from where you will not be arrested? Parliament. If the speaker or the chairperson of Rajya Sabha is your friend or is known to you, in a sense, no person, whether you are a member or an outsider, can be arrested, and no legal process, whether civil or criminal, can be served within the precincts of the house without the permission of the presiding officer. An MP has committed murder. The police is waiting outside the parliament. They cannot enter inside the parliament without the permission of the presiding officer. If the presiding officer does not give the permission, the police cannot enter. If the presiding officer gives the permission, then the police can enter, or the police may ask this MP, come out, we will arrest you. Otherwise, we will have to come in. Or if you are a friend of a speaker or a presiding officer, after committing murder, you can run to the parliament and enter the parliament. Now, you can stay there for your entire life. Unless and until this presiding officer gives the permission, you cannot be arrested. That's the privilege available to parliament as an institution. Similar privilege as is available to, let's say, the diplomats. For example, there is another place where you can enter and no action can be taken against you if it is the house of a diplomat, if it is the foreign embassy in India. You might have heard of Julian Assange case, the founder of WikiLeaks. For many, many years, he was inside the embassy of a different country, Ecuador, in Britain, despite the fact that the Britain police, the Scotland Yard, they were looking for him. They knew that this person is inside, but they could not have entered inside. Because without the permission of the head of that mission, you cannot enter that embassy. For example, if you are friends with a Canadian diplomat and you have committed any murder, enter the Canadian embassy, stay there for your entire life without the permission of the head of Canada in India. No army, no police can enter this place. Or if you're not feeling satisfied in the embassy, you want a home atmosphere, go to the home of the foreign ambassador in India. That place is also inviolate. The police cannot enter the private residence of a diplomat without the permission of the diplomat. That's according to Vienna Convention. These are individual and collective privileges available to Parliament as an institution and MPs. If you have any doubts, please let me know. Sir, voting takes place in Parliament on the report of Ethics and Privileges Committee. Yes. Himanshu says no doubt. Bikash, what is MPC? Are you talking about Monetary Policy Committee? That is the committee of the RBI to decide the monetary policy. This is applicable to embassy in India also? Yes. Is the British privileges to decrease the honor of our country. That time any action can be taken. Action cannot be taken against him in a court of law, but action can be taken against him by the parliament itself. So you can go to the court, but the court will be very limited in its jurisdiction. Now let's look at passage of bills. If you are a student of public administration as an optional, you will have to understand this topic in great detail. But from GS perspective, you just need superficial understanding of this topic and then you're done for GS. Bills normally go through three stages. First reading, second reading or report stage of the bill, third reading or third stage. Reading, you're reading the bill for the first time, then you're reading it again, then you're reading it again to make it foolproof, and ultimately the bill is passed. What is a bill? Bill is a proposal. Let's say the proposal is to increase, or let's say the proposal is to decrease the age of consent. Right now, the age of consent is 18. The proposal is to decrease it to, let's say, 14, or let's say decrease it to 16. Age of consent, that means the age at which a girl can give her consent to a sexual interaction. Right now, the allegation is, various reports are, even the judiciary is saying the same thing, that there is a girl and a boy in a consensual relationship. They are in a relationship. But both the girl and the boy, they are less than the age of 18. But let's say the boy is of 16 years old, the girl is also of 16 years old. They are in a consensual relationship with each other and they get sexually involved as well. The parents of the family, the girl family, they get to know and they file a case of rape against the boy. This boy who is of the age of 16, according to the Juvenile Justice Act, any boy in the age group of 16 to 18, if he has committed a heinous crime, he can be tried as an adult. Rape is a heinous crime. So this boy of the age of 16 is now accused of rape. Although it's a consensual relationship. But this consent is of no value. Why? Because we say a girl below the age of 18 cannot give her consent. And then the Supreme Court, various child organizations, they are basically saying that you are penalizing, prosecuting, criminalizing consensual activity of adolescents. That is why there is a need that we should reduce the age of consent from maybe 18 to 16, or some say even to 14. This is a bill. This bill has to be passed by the parliament and it goes through various stages. Stage number one, first reading of the bill. Let's say, for example, I am the member of the Lok Sabha. I will introduce this bill in the Lok Sabha. But for that, I have to do some background checks. There is some background work that I have to do. And what is that background work? how would the speaker know that what are the questions to be asked by the parliamentarians? What are the kind of bills presented by the parliamentarians? That means if the session of the parliament begins from 1st of December, even before that, the Business Advisory Committee meets, which is headed by the speaker. This Business Advisory Committee will have representatives of all the political parties inside the parliament. That means all the political parties, based on their representation, based on their strength, they will get representation in this Business Advisory Committee. And ultimately, it is this Business Advisory Committee which gives you the time. I submitted this application before the BAC, Business Advisory Committee, that I want this bill to be introduced. Now, BAC will allocate me the date and time when I can introduce this bill in the Lok Sabha. It will also give me the time duration. For how much time duration can I speak on this bill while I am introducing this bill in the Lok Sabha? I've got the permission from the BAC. On this particular date, I can introduce this bill. Now, what I'm doing, I am introducing this bill in the Lok Sabha, of which I am a member. I am also giving a speech outlining the need for such a bill. What is the objective that will be served if this bill is passed by the parliament? And ultimately, it is published in the government gazette. Just like we have Current Affairs Monthly magazine, where whatever happened in the last 1 month, we make content of it, upload it on the app, upload it on the website, give it to the students. In the same manner, government also has its weekly magazine, a magazine known as the Gazette, which is updated weekly. And whatever proceedings happen inside the parliament, that is also published in that Gazette. This is what we call first reading of the bill. That means in first reading of the bill is introduced in the Lok Sabha by the member. Then I give a speech outlining what is the need of this bill, what is the purpose that we seek to achieve through this bill, and ultimately it is published in the government gazette. This is what we call constitutes the first reading of the bill. This may also happen in Rajya Sabha. I am introducing a bill in the Rajya Sabha, giving a speech, what is the purpose of this bill, what are the objectives that we seek to achieve through this bill. At the end of that speech, this bill is published in the government gazette. This is what we say constitutes the first reading of the bill. Then the second reading of the bill, this is where the final shape of the bill gets determined. What is that final shape of the bill gets determined? That means in this second stage, this bill may be sent to select committee of the parliament, may be sent to joint committee of the parliament, may be sent to elicit public opinion. What does that mean? If this bill is introduced in Lok Sabha, first reading is done, then after a few days, we have to take action on this bill. One action can be refer this bill to the select committee of the parliament. That means if this bill is introduced in Lok Sabha, select committee members will have members only from this particular house. Or parliamentary committee. That means there are now various options. One option is that this bill be sent to a select committee of the parliament. That means members of the select committee will be only from that house. If this bill is introduced in Lok Sabha, Select committee will have members only from Lok Sabha. Or this bill may be sent to joint parliamentary committee. Let this bill be sent to a committee which will have members from both the houses, Lok Sabha as well as Rajya Sabha, because this bill will go to the other house. Both houses have to pass this bill. Or this bill may be sent to elicit public opinion. Publish this bill on the government website and ultimately seek opinion of the public, seek opinion of the activists, seek opinion of the intelligentsia, and basis that report, we will see how we can tweak this bill, how we can make this bill better. Or we can refer this bill to a parliamentary committee. What parliamentary committee? For example, if it is related to this issue, we can send this matter to Women and Child Development Ministry. Women and Child Development, a parliamentary committee which is responsible for looking into the parliament, looking into the Ministry of Women and Child Development. Because when we look at parliament, there are various committees which are responsible for the functioning. Committees. There is a parliamentary committee, that is what we call Parliamentary Standing Committee on Law and Justice, Parliamentary Committee on Home Affairs, Parliamentary Committee on Finance, Parliamentary Committee on all the ministries that we have. This is something that we will understand in great detail when we will discuss budget. Because once the budget is introduced, then we go to these departmentally related standing committees and they analyze what is the demand of each ministry, why do they need this much money, what have they done with the money which we gave them previously, what are they going to do with the money that they are proposing. Everything is detailed and dissected by these parliamentary committees. And this is where the shape of this bill may be determined. The final shape of this bill may be determined. What is that final shape? Because all these things will also lead to various reports. That means if this bill talked about that we should lower the age of consent from 18 to 14, maybe the select committee will say no, lower it to 16. Or if this bill is sent to a joint parliamentary committee or to elicit public opinion, maybe some would say no, increase it to 21 or reduce it to 10, reduce it to 12, or these should be the exceptions provided. Ultimately, the basis of these reports, now report will be presented to the parliament, and now we will enter the third stage. Third stage is a mere formality. Formality in the sense voting takes place. Whether the bill is accepted, whether these reports are accepted, incorporated into the bill or not, or whether the bill in its original form is adopted. That is how voting takes place, clause by clause. Now listen to me carefully, this is the flow. I am introducing a bill in Lok Sabha. I give a speech. What is this bill all about? What is the purpose that we are going to achieve through this bill? And after this speech, this bill is notified in the government gazette. Now everybody has the copy. All the members of the Lok Sabha, they have the copy of this bill. Now we enter the second stage. In the second stage, when everybody is reading the bill, instead of all the people taking a decision, is it not better that we create a select group so that instead of the entire parliament looking at this bill, we will have a select group of people looking into this bill? In a sense, let's say we have to have a prelims test series tomorrow. And we have 50-member content team, those who are making questions, for example. Can we say that all these 50 members, you start making questions of all the subjects? Is this a better solution, or the better solution will be 10 will make questions on polity, 10 will make questions on economy, 10 will make questions on modern history, 10 will make questions on geography, 10 will make questions on current affairs? Is this the better approach? Or then all these 50 members will together decide whether these questions are good or bad, whether these should be incorporated or not? Or should we have a separate team of 5 members who will then decide whether these questions are good or bad? Because if the entire team is to again decide whether these questions are good or bad, it will consume a lot of time. because all these members will have to now look at individual questions and see whether these questions are good or bad. Instead, we can have committees. One committee will look into polity questions, another committee will look into economy questions, another committee will look into geography questions. In the same manner, Parliament has a lot of business to do, lot many bills to pass. If the entire Parliament has to look at all bills individually, they will not have time to make a good law. They will not make a better law. Because number one, Parliament is not always in session. We have 3 sessions in the Parliament. Number two, if the entire Parliament will have to look at all bills individually, ultimately what will happen? We can focus on only few bills. The remaining bills we will never be able to focus on because we don't have time. Instead, if there are 10 bills, send these 10 bills to 10 committees, so that inside these committees, they will thoroughly debate these bills and submit their report. That is the beauty of these select committees. Create a select committee specific for this particular issue and then decide whether this bill should be passed or not, whether this bill is good or not. Select committee will give its report. But ultimately, this report is to be accepted by Lok Sabha. Now, all these bills, this particular bill, clause by clause, will have to be voted upon by the Parliament. I, as the Speaker, will say, this bill is now put to vote. Clause 1 of this bill, those who are in favor may say A. I think the A's have it, the clause is passed. There is one amendment to this bill by this opposition member. Those who are in favor of incorporating this amendment into this bill may say A. Those who are against may say no. I think the noes have it, the amendment is rejected. If the government is introducing an amendment, if a government minister is introducing an amendment, those who are in favor of this amendment may say A. Those who are against may say no. I think the A's have it, this amendment is accepted. So clause by clause, voting takes place and ultimately the bill is adopted. When the bill is passed by Lok Sabha, it is then sent to Rajya Sabha. And in Rajya Sabha also, it goes through these stages. And ultimately, the bill is passed and sent to the President for signature. This is what we call passage of bills. But bill can be an ordinary bill. And I told you yesterday, what is an ordinary bill? An ordinary bill is a bill which is neither a money bill, nor a financial bill, nor a constitutional amendment bill. This bill can be introduced by a private member or by a minister. Prior recommendation of the President is not required, except Article 3. This bill should be passed by both houses of the Parliament. In case there is a deadlock, what happens? Joint sitting of the two houses can be convened. And in this joint sitting of the two houses, this bill requires simple majority. And since Lok Sabha has a numerical strength, a better numerical strength than the Rajya Sabha, the will of Lok Sabha prevails. And 3 times in the past, joint sitting has been convened. Last one in 2002 related to POTA, Prevention of Terrorism Act. A bill is passed by one house, rejected by another house. There is a deadlock. To resolve this deadlock, joint sitting of the two houses. A bill is passed by one house, amended by the other house, but these amendments are not acceptable to the first house. Deadlock. To resolve the deadlock, there is a joint sitting of the Parliament. A bill is passed by one house and is not acted upon by the other house for 6 months. At the expiry of the 6 months, there may be a joint sitting of the two houses, convened and notified by the President of India on the advice of the Council of Ministers and the Prime Minister. And in this joint sitting, both Lok Sabha as well as Rajya Sabha MPs, they will come together. 543 Lok Sabha MPs, 245 Rajya Sabha MPs, total 788. And ultimately, what will happen? The bill is to be passed. And this bill is passed by simple majority. That means more than half of the members present and voting. Since more than half already are the members of the Lok Sabha, that means the will of Lok Sabha prevails in this joint sitting. But who presides over this joint sitting? Who presides a joint sitting? First opportunity is given to Speaker of Lok Sabha. If Speaker of Lok Sabha is not present, Deputy Speaker of Lok Sabha. If Deputy Speaker also is not present, then Deputy Chairperson of Rajya Sabha. If Deputy Chairperson also is not present, then any member chosen at the joint sitting. Which means under no circumstances does the chairperson of Rajya Sabha preside over joint sitting. Speaker of the Lok Sabha, he will be the first person to preside over this joint sitting. If he is not present, then the Deputy Speaker of the Lok Sabha. If Deputy Speaker is also not present, then the Deputy Chairperson of Rajya Sabha. If Deputy Chairperson is also not present, then any member can be chosen at this joint sitting. Any member means can be from Lok Sabha, can be from Rajya Sabha, as decided by the House, as decided by the majority. Under no circumstance does the chairperson of Rajya Sabha preside over joint sitting. Why? Because he is not the member of the parliament. This is the joint sitting of both the houses. That means only those who are the members of both the houses, they will participate in this joint sitting. Since the chairperson of Rajya Sabha, who is the vice president of India, is not a member of the Rajya Sabha, he cannot preside over the joint sitting of the two houses. Clear? Introduces a bill in the parliament. Is prior approval necessary or not? Whether it is an ordinary bill or a constitutional amendment bill, prior permission of the president is not required. Who is a private member? Somebody who is not a minister. So Dr. Shashi Tharoor introducing a bill in Lok Sabha is a private member's bill. Asaduddin Owaisi introducing a bill inside the Lok Sabha, it's a private member's bill. Mr. Varun Gandhi, who is from the ruling party, introducing a bill becomes a private member's bill because he's not a minister. Kritika, what's your question, please? Sir, then that person will not come out of parliament whole year. He will not come out. Payal, has it happened? It hasn't. When it has not happened, so don't worry about it. Don't assume that this person will never come out, because then media will raise a lot of hue and cry. Ultimately, that person will have to be arrested. Explain why chairperson of Rajya Sabha does not preside joint sitting, because he is not the member of parliament. Sir, if freedom of speech absolute, since they cannot speak about the judge's conduct in parliament. Yes, you're right. The only limitation of the members of the parliament when they use their freedom of speech and expression is that they cannot discuss the conduct of judges inside the parliament. So, and it is given, just like judiciary cannot interfere in the parliamentary proceedings, parliament cannot interfere in the judicial proceedings. But if we have to remove a particular judge For that, both houses of the parliament will have to pass a resolution. How can they pass a resolution unless and until they know what they are discussing? Unless and until they can discuss what are the allegations against that judge. In that case, they can discuss the conduct of that particular judge. Otherwise, no. If majority of members abstain, then bill will be passed. You tell me common sense. What does common sense tell you? That means the majority are not in favor of this bill. This bill will not be passed. Majority has to vote in favor of this bill for to be passed. Otherwise, it won't be passed. That the speaker would vote after every member have done their voting. Not even then, unless and until there is a tie, he will not vote. Sir, if MP did not attend session, then also he will be immune from arrest? Yes. Prior notice required for private members bill? Yes, you have to seek the permission of the Business Advisory Committee. Sir, NJAC is abolished. Can Parliament again introduce this bill? Yes, but with considering what the judgment of the court is. If you pass the same bill again, court will strike it down again. So all the concerns raised by the judiciary on NJAC, you will have to incorporate those concerns, which we will discuss. Why there is, whether you are in favor or against. For that, there is an electronic switch provided to you in Lok Sabha and in Rajya Sabha. You just have to press the button yes, press the button no, press the button abstain, which means you're abstaining, which means you're voting, which means you're not voting. That's it. Why should ballot paper be involved? Okay, let's take a break. After the break, let's meet at 7:45 and discuss money bill and financial. Freedom by the parliament. That means in the court of law, they cannot be prosecuted. So if you have violated 3-line whip, courts cannot take action against you. But the speaker can take action against you and disqualify you. That's the difference. Okay. Now let's look at what is a money bill. A bill is considered to be a money bill if it satisfies the conditions mentioned under Article 110 of the Constitution. So any bill which deals with money matters, such a bill is a money bill. Now what are these money matters? Only those money matters which are mentioned under Article 110 of the Constitution. Such a bill is a money bill. For that, I will tell you that we have something known as Consolidated Fund of India. For that, we have something known as the Public Account of India. And then we have Contingency Fund of India. Consolidated Fund of India and Public Account of India, these are constitutional funds. What is a constitutional fund? A fund which is created by the Constitution. Under Article 266 of the Constitution, there are these two funds, Consolidated Fund of India and Public Account of India. Then we have Contingency Fund of India, which is optional. Optional in the sense that may be created. Article 267 of the Constitution says If the Parliament wants, it can create a fund for contingency needs. Contingency needs means for some emergencies. And for that, in 1950, Contingency Fund of India Act was passed, and then Contingency Fund of India was created. That means Contingency Fund of India, it is basically a statutory fund. That means a fund created by the act of the Parliament, the law passed by the Parliament. It's not a constitutional fund. There are two constitutional funds, Consolidated Fund of India and Public Account of India. This is operated via legislature, or should we say by a legislative act. Public Account of India and Contingency Fund of India, they are operated via executive action. What is the difference? Consolidated Fund of India, all the money which is raised by the government of India, all the taxes that you and me pay or the corporates pay in India, they get deposited in the Consolidated Fund of India. All the loans that are taken by the government of India, all the investments that are taken by the government of India, they get deposited in this fund known as Consolidated Fund of India. And you cannot withdraw even a single penny from Consolidated Fund of India without the approval by the legislature. That means who controls this fund? Legislature. If the executive has to withdraw even a single penny from Consolidated Fund of India, for that legislature has to approve. How will legislature approve? By passing a law. And what is that law? That law is a money bill. Clear? Then we have a fund known as Public Account of India. For example, your PF deposits. These are mostly in nature of banking transactions. For example, you have your PF money, your banking transactions, all these get deposited into a fund known as Public Account of India. And the money can be withdrawn by the executive from this Public Account of India without any need for parliamentary approval. Parliamentary approval is not required. And then we have a contingency fund which is also operated through this. It is kept under the custody of the president and operated by the finance secretary. That means the money from contingency fund can also be withdrawn by the government at any point in time without approval of the parliament. But the approval of parliament is required if you withdraw money from Consolidated Fund of India. And how will legislature approve? By passing a law. And such a bill is known as a money bill. That is one example of a money bill. So basically, a bill is a money bill if it deals with money matters. And now, which are these money matters? Only those money matters which are mentioned under Article 110. For example, withdrawal of money from Consolidated Fund of India, such a bill is a money bill. I will give you more examples of a money bill, but first let's understand the procedure. A money bill under Article 110 of the Constitution can be introduced only in Lok Sabha, that too with prior approval of the president. A money bill is a money bill if it deals with only those money matters which are mentioned under Article 110. But this money bill can be introduced only with the prior permission of the President of India, that too only in Lok Sabha. It can be introduced in Lok Sabha only. Now you will say, why Lok Sabha? Lok Sabha is directly elected by people. Rajya Sabha is not directly elected by the people. Now you will say, what difference does it make? There was a movement in United States, no taxation without representation. So if taxes are to be imposed, taxes can be imposed only by the representatives of the people. So there should be no taxation without representation. It is in the same spirit that there are two reasons why money bill is introduced only in Lok Sabha and why Lok Sabha has more power vis-a-vis Rajya Sabha when it comes to a money bill. Reason number one, no taxation without representation. So only our representatives can impose taxes on us. Any bill which imposes taxes is a money bill. Any bill which imposes taxes, increases taxes, such a bill is a money bill. Any bill which reduces taxes, abolishes taxes is a money bill. So a bill is a money bill if it deals with only money matters. One such money matter is withdrawal of money from Consolidated Fund of India, imposition of tax, alteration of tax, abolition of tax, all these tax related provisions, these are money bills. And money bills can be introduced only in Lok Sabha. Reason number one, no taxation without representation. Reason number two, Council of Ministers, including the Prime Minister, they are responsible to Lok Sabha. They are not responsible to Rajya Sabha. Lok Sabha is directly elected by the people. The government has to start a scheme. For that running of scheme, we need money. Where is this money going to come from? Consolidated Fund of India. Imagine the government has to launch an insurance scheme for the people. They have to provide scholarships to the people. They have to provide old age pension to the people. They have to provide some benefits to girls. Where is this money going to come from? Consolidated Fund of India, because this is where almost the entire money is deposited. But you can't withdraw this money without passing a money bill, without passing a money bill, without passing a law. What if the government does not have the majority in Rajya Sabha? Then government cannot do anything. Government needs money for any purpose. Lok Sabha is approving, Rajya Sabha is not approving, which basically means the government will not have any money to run because Rajya Sabha would not approve. It is for this reason that since for running of the government, money is important and government is accountable to Lok Sabha should have and will have more powers when it comes to money matters. That is why this bill under Article 110, which is known as a money bill, can be introduced only with the prior approval of the President of India, that too only in Lok Sabha, and then this bill requires simple majority in Lok Sabha. Once this bill gets simple majority in Lok Sabha, this bill now travels to Rajya Sabha. What are the options available with Rajya Sabha? Rajya Sabha cannot But yesterday, sir told President enjoys discretion over the appointment of Speaker pro tem. Please ask him to clarify to all students. Yes, I'm saying it again. President has the discretion in appointing pro tem Speaker. Where is the confusion, Suraj? Suraj, if you can hear me, where is the confusion? I can't see your previous comment. You can mention your comment now. This money bill is introduced in Lok Sabha only with the prior approval of the President of India. In Lok Sabha, it requires simple majority. If it gets simple majority, then it travels to Rajya Sabha. Rajya Sabha cannot reject a money bill. Rajya Sabha cannot amend a money bill. Rajya Sabha can make recommendations to a money bill. Or Rajya Sabha may not act on the bill. These are the options. So when the Rajya Sabha gets this money bill, First, this is certified by the Speaker. Suraj question, even after resignation of Council of Ministers, it shall continue to act as a caretaker government until the next Council of Ministers swears in. Thus, there shall always be Council of Ministers and no discretion of President over the appointment of Speaker pro tem. Now, you are mixing two concepts. Let's say Prime Minister resigns or the Prime Minister is defeated in Lok Sabha. What will the President do? President will ask this Prime Minister to continue. And that is what we call as the caretaker Prime Minister. That means you will continue till we have the next election or till we have the next Prime Minister elected. You are then mixing it with pro tem Speaker. In appointment of pro tem Speaker, President has the discretion. The President can appoint the senior most member of the Lok Sabha as the Speaker pro tem. So these two concepts, they don't gel with each other. Okay. What is the difference between amending a bill and making a recommendation? For example, amendment would be if there are 10 clauses in a bill, if the other house replaces these 10 clauses with their own 10 clauses, or deletes 5 clauses, or adds 2 more clauses, that's an amendment. So you are amending a particular bill. Money bill cannot be amended by Rajya Sabha. Money bill cannot be rejected by Rajya Sabha. What Rajya Sabha can do, it can make recommendations. Recommendations are, these 10 clauses will remain the same, but an additional paper will be added mentioning the recommendations. So this should have been added, this should also be added, this should not be added. These are recommendations. So you're not touching the bill itself. You're not making any changes in the bill. You're basically adding another paper with the recommendations of Rajya Sabha. If these recommendations are acceptable to Lok Sabha, the bill is passed. Because Lok Sabha has accepted the recommendations of Rajya Sabha. But Rajya Sabha cannot reject a money bill, cannot amend a money bill, can make recommendations to a money bill, or may not act on this money bill. When Rajya Sabha decides not to act on this money bill for 14 days, after the expiry of 14 days, the bill shall be deemed to have been passed by both houses of the Indian Parliament. That means even if Rajya Sabha does not act on this bill for 14 days, 14 days are over, we will say Rajya Sabha has also approved this money bill. That is why we say in case of a money bill, Rajya Sabha has an inferior role to play. Because Rajya Sabha is not directly elected by the people. Because no taxation without representation. And then this bill is sent to the President, who normally gives her assent. Who normally gives her assent, because it was on her recommendation that this money bill was introduced in the Lok Sabha. But President does have the power. President can either assent or withhold her assent. Which means either she can give her assent, sign this money bill, or she can use absolute veto. This President cannot send the money bill back for reconsideration. A money bill introduced in the Lok Sabha, which means it always has to be a government bill. It cannot be a private bill. It cannot be a private member's bill. A money bill is a government bill introduced by a minister with the prior approval of the President of India in Lok Sabha. If it gets simple majority in Lok Sabha, it travels to Rajya Sabha. Rajya Sabha cannot reject, cannot amend, but can make recommendations. Or Rajya Sabha may not act on this money bill for 14 days. After the expiry of 14 days, we say this money bill has been passed, approved by both houses of the parliament by simple majority. If the recommendations given by Rajya Sabha are acceptable to Lok Sabha, the money bill is passed. Then it is sent to President, who normally gives her assent because it was on her recommendation that this money bill was introduced in the parliament. But President still can either give her assent or withhold her assent to a money bill. She can use absolute veto. But the one thing that she cannot do, she cannot send the money bill back for reconsideration. That is mentioned under Article 110 of the Constitution. And once money bill is passed, this becomes an act. Now, through this act, you can withdraw money from Consolidated Fund of India. That is why we say Consolidated Fund of India is operated through Legislative Act. Once the legislature approves, you can withdraw money from Consolidated Fund of India. Now, there can be, and there should be a question on your mind, sir, what if in Lok Sabha, money bill is defeated? It may also happen that a money bill is introduced in Lok Sabha. Instead of getting simple majority, it is not getting simple majority. It is defeated in Lok Sabha. If it is defeated in Lok Sabha, the Council of Ministers, the Prime Minister has to resign. Because this amounts to lack of confidence in the government. The defeat of money bill leads to the defeat of the government. If the money bill is defeated in the Lok Sabha, it means that Lok Sabha does not have the confidence in the Prime Minister and the Council of Ministers. The Prime Minister has to resign. One aspect of that is collective responsibility. And this collective responsibility, this aspect of collective responsibility, we did not discuss then. Now we are discussing here. Does that mean when Prime Minister and his Council of Ministers have to resign, all these individual ministers one by one will have to submit resignation to the President? Or is the Prime Minister's resignation sufficient? Resignation of Prime Minister means resignation of the entire Council of Ministers. Individual ministers, they don't have to submit their individual resignations to the President. Resignation of Prime Minister means resignation of the entire Council of Ministers. That is why we say these Council of Ministers swim and sink together. The death of a Prime Minister means death of the entire Council of Ministers. What does that mean? 1984, the Prime Minister, Srimati Indira Gandhi, was assassinated. She's dead. What will happen to the entire Council of Ministers? Dead. Dead in the sense they are gone. There is no government. Now a new Prime Minister is to be appointed. This old Council of Ministers is also gone because with the death of the Prime Minister, this Council of Ministers is also gone. Now a new Prime Minister is to be appointed. And now this new Prime Minister will advise the President who is going to be the minister, who all are going to be the next ministers, who is going to be part of Council of Ministers. Because the resignation of the Prime Minister means the resignation of the entire Council of Ministers. The death of the Prime Minister means this Council of Ministers is also dead. This whole Council of Ministers is dead. Now a new Prime Minister is to be appointed, and now this new Prime Minister will advise the President about the composition of his Council of Ministers. That is why when Shri Rajiv Gandhi was appointed as the Prime Minister, the Council of Ministers, they were sworn in again. That means another oath of office and secrecy was administered to them because now they have a new Prime Minister. And if the money bill is defeated in the Lok Sabha, it does not get simple majority. It means that Prime Minister has to resign, which basically means using collective responsibility, the entire Council of Ministers is gone. A new Prime Minister needs to be appointed. Clear? Money bill. But what is a money bill basically? We say a bill is a money bill if it deals with only money matters. Which are these money matters? Only those money matters which are mentioned under Article 110. Which are these money matters? I will give you a few examples. Imposition, abolition, remission, alteration, or regulation of any tax. Does it ring a bell? Do you know something about the budget? Budget is basically a money bill. Why? Because this budget has two components: withdrawal and imposition. Withdrawal of money, that means the money that you want to spend, and revenue that you want to raise. Withdrawal of money from Consolidated Fund of India, because in budget all the schemes that are mentioned, for that we need some money. This money is going to come from Consolidated Fund of India, and you can withdraw money from Consolidated Fund of India only with the approval of the Parliament. Such a bill is a money bill, so budget is a money bill. But budget has other component as well. It imposes taxes. From now onwards, let's have a Swachh Bharat cess. Let's have a Krishi Kalyan cess. Income tax rates are changed. On this particular income group, now additional surcharge is to be imposed. These are all taxation matters. All these taxation matters are money matters and basically is a money bill. Similarly, appropriation of money from Consolidated Fund of India. You're appropriating money from Consolidated Fund of India. You're withdrawing money from Consolidated Fund of India. Such a bill is a money bill. The declaration of any expenditure to be expenditure charged on the Consolidated Fund of India. Now, this is another important concept. What is this? Is Consolidated Fund of India. On that, we have two types of expenditures. Expenditure charged, expenditure made. Very easy concept, but listen to me carefully. We have to start a new scheme. Let's say in this scheme, we want to provide subsidized food or scholarships or pensions to the people. That will involve spending the money. Where is this money going to come from? Consolidated Fund of India. Such expenses are expenses made on Consolidated Fund of India. That means what Parliament will do, Parliament, Lok Sabha for example, Lok Sabha will discuss all these expenditures. If Lok Sabha agrees, Lok Sabha will pass this bill and say, okay, you can spend this money. That means there will be discussion on all these expenditures made. Then there will be voting as well. Discussion plus voting. Which means Lok Sabha, you have to convince Lok Sabha that for this particular scheme, we need 10,000 crore rupees. Lok Sabha will discuss, for this scheme, do we really need 10,000 crore? If yes, we will pass this money bill. You can spend, withdraw 10,000 crore from Consolidated Fund of India. This is what we call expenditure made. Then there is something known as expenditure charged on the Consolidated Fund of India. Charged in the sense, I'll give you a simple example. You have a credit card. Okay. On this credit card, you make auto debit facility available. Auto debit facility means there is one website, news website known as Morning Context, publishes beautiful articles. I want to subscribe to this Morning Context. For that, I have to pay 399 rupees every month. What I have done, I have made auto debit facility available, which means every month Morning Context will debit 399 rupees from my credit card. Every time I don't have to give it approval. Auto debit facility. Similarly, there are some expenses for which every time we don't need to vote. Once these expenses are decided without any voting by the Parliament, you should be able to withdraw money from Consolidated Fund of India. That is what we call expenditure charged. There will be discussion on this expenditure charged, but there will be no voting. And what is this expenditure charged? Imagine a situation that we have the President of India. Her salary is 5 lakh rupees a month. Clear? Where is this money going to come from? Consolidated Fund of India. We have the judges of the Supreme Court. Where are their salaries going to come from? Consolidated Fund of India. Done? But imagine a scenario, and this is where our founding fathers of the Constitution, they envisaged independence of important constitutional functionaries. Imagine a situation that there is a petition pending before the court on the validity of the government's actions on August 5 and 6 related to Article 370. Now, the Supreme Court, 5 judges of the Supreme Court, headed by Chief Justice Chandrachud, will have to give its verdict. What if the government says, you give us a favorable verdict, we will release your salary. If you don't give us a favorable verdict, we will stop your salary. Can we ensure independence of judiciary then? Judiciary will think that if we don't give a favorable verdict, our salary will be stopped. So we have to give a favorable verdict to the government. Similarly, we have the President of India. President, sign this bill. If you don't sign this bill, we will stop your salary. How can we ensure independence of the office of the President? CAG, Comptroller and the Auditor General of India. Dr. Ambedkar was asked, which is the most important, crucial, critical office under the Constitution? He said, number 1, CAG. Who is the CAG? Auditor. What is the role of the auditor? All this money that has been spent from Consolidated Fund of India, somebody should audit whether this money was really spent on that or not. If the government withdrew money from Consolidated Fund of India to give pension to old age people, was that money really spent on that, or was it spent on the dresses of the Prime Minister? If this money was to be spent on providing scholarships to the kids, was this money spent on refurbishing or renovating the personal house of Mr. Amit Shah? Somebody has to check this. So somebody has to do the audit. What if we say that CAG, we will not release your salary if you don't approve this report? Don't mention that we have spent this money on the dresses of the Prime Minister or the personal office of the Home Minister or the family members of the Home Minister. Don't do that. Otherwise, we will stop your salary. Can these important constitutional officers work independently? No. It is for this reason that important constitutional officers, their salary is charged on the Consolidated Fund of India. Once it is charged on the Consolidated Fund of India, every year you don't have to pass a bill, a money bill. Every month you don't have to pass a money bill to withdraw this money and pay these important constitutional functionaries. Once it is charged on the Consolidated Fund of India, no matter, even if the bill is not passed, even if the budget is not passed, no matter what happens, this money will be given, this salary will be given to President, to the chairperson of Rajya Sabha, to the deputy chairperson of Rajya Sabha, to the speaker of the Lok Sabha, to the deputy speaker of the Lok Sabha. Salaries, allowances, even the pensions of Supreme Court judges, salaries, allowances and pensions of the CAG, members and the chairperson of the UPSC. That is expenditure charged on the Consolidated Fund of India. Any sum required to satisfy any judgment, decree or award of any court or tribunal. Let's say tomorrow, the Supreme Court says compensation should be provided to the rape victims. Where is this money going to come from? Lok Sabha need not vote. Even then you can withdraw money from Consolidated Fund of India. Because we say any money which is there in Consolidated Fund of India cannot be withdrawn without parliamentary approval. But there is some money which can be withdrawn even without parliamentary approval. That is what we call charged expenditure. So if the Supreme Court has said give 20 lakh compensation to this rape victim, central government should pay the compensation. You have to withdraw money from Consolidated Fund of India, 20 lakhs, even without parliamentary approval. Why? Because this is to satisfy the judgment of the court. Any other expenditure declared by the parliament to be so charged. If you look at this list, there is one constitutional office which is surprisingly missing. And which is that constitutional office? Election Commission of India. How can we ensure the independence of Election Commission of India if the salary allowances of the CEC and the election commissioners are not charged on the Consolidated Fund of India? Which means they will come under the influence of the executive. You see, dates of the election coincide with my birthday, because I will organize a rally on that time. At that time, I will say it is my birthday. People have come to wish me, and I will pay them money to vote for me. If you don't do that, we will stop your salary. The government can't do this because the salary allowances of election commission, they are not charged on the Consolidated Fund of India. But sir, what does it take to make allowances and salaries of election commissioners and chief election commissioner also charged on the Consolidated Fund of India? For that, you need to pass a bill. A bill should be presented before the parliament, that this bill now has a proposal that the salaries of election commissioners and chief election commissioner is also charged on the Consolidated Fund of India. This bill, which says that there is one more charged expenditure, such a bill also becomes a money bill. That is what Article 110 talks about. Article 110 says any bill which deals with only money matters. And which are these money matters? Only those money matters mentioned under Article 110. Such a bill is a money bill. What are these money matters? Imposition of tax, alteration of tax, remission of tax, abolition of tax, withdrawal of money from Consolidated Fund of India. Any declaration of any expenditure to be charged on the Consolidated Fund of India. If tomorrow you want to include my salary also to be charged on the Consolidated Fund of India, for that a money bill should be passed in the parliament. But we are not here to become lawyers. We are here to qualify the exam. And for that, there is one last clause which is important for you to understand. And what is that last clause? Any bill is a money bill if it contains any matter incidental to any of the matters specified above. What are these matters? Let me answer your question. Some of you have been asking, sir, what about Aadhaar? Aadhaar was passed as a money bill. How was it passed as a money bill? But to understand that, we first need to understand what is a financial bill. And once you understood what is a financial bill, then we will go back to money bill and understand Aadhaar. What is a financial bill? Financial bill is mentioned under Article 117. What is financial bill? Financial bill is a money bill plus something else. And what is this something else? Non-money matter. A bill which is a money bill, which has money matters plus non-money matters as well. Such a bill is a financial bill. Financial bill is under Article 117. Money bill is under Article 110 plus non-money matter. Such a bill is a financial bill. Can we then say all money bills are financial bills? And not all financial bills are money bills. Money bills are financial bills. All money bills, they have some money matter as well. But not all financial bills are money bills. Can we say this? Or can we say the reverse? All financial bills are not money bills, but all money bills are financial bills. Or all money bills are financial bills, but not all financial bills are money bills. What is the difference? This financial bill under Article 117 can be introduced only in Lok Sabha, with the prior approval of President. To pass, it requires simple majority in Lok Sabha. If it is passed, then it travels to Rajya Sabha. Rajya Sabha can reject a financial bill, can amend a financial bill. In case there is a deadlock, there may also be the joint sitting of both the houses. Once Rajya Sabha also passes this, President can enjoy veto. Even if defeated in Lok Sabha, does not lead to fall of the government. What is a financial bill? Financial bill is a bill if this bill contains some money matters, but some non-money matters as well. And I will give you the example. But such a financial bill can be introduced only in Lok Sabha with the prior approval of the President of India. And in Lok Sabha, it requires simple majority. If it is passed by simple majority, it travels to Rajya Sabha. But Rajya Sabha now has an equal role vis-a-vis Lok Sabha on this financial bill. Rajya Sabha can reject a financial bill. It can amend a financial bill. It may not act on the financial bill for 6 months. At the expiry of 6 months, there is a deadlock. And to resolve this deadlock, there can be a joint sitting of both the houses of the parliament. And once it is sent to the president can give his assent, withhold her assent, send the bill back for reconsideration as well. And even if this financial bill is defeated in Lok Sabha, does not affect the stability of the government survives. The government need not resign. But what is this financial bill which has money matter plus something else as well? I'll give you one hypothetical example or a real life example. Let's say the government imposes cess. What is a cess? Tax for a specific purpose. For example, Swachh Bharat cess. It's a tax. Whenever you go out in a restaurant, eat something, you check the bill copy, there will be Swachh Bharat cess, or there will be education and health cess. Education and health cess is for specific purpose. That means whatever money is generated through this cess will be used only and only for health and education, will not be used for any other purpose. Let's say, for example, a bill has been introduced And this bill talks about imposition of cess on petrol and diesel. Whenever you go to a filling station, you want petrol or diesel, on that you have to pay cess extra. This money will be used for the construction of highways. That means for a specific purpose, only for highways. But for that, we will set up a body. We will set up an authority. Let's say this authority is National Highways Authority of India Limited. What is the composition of this institution? Who is going to be the chairperson? Who are going to be the members? What is the qualification of these members? How can they be removed? Who will conduct the audit of the entire money that is raised through this cess? Who will do the performance analysis? What should be the quality of the highways constructed? That means this bill, apart from talking about a money matter, which is cess, cess is basically a tax for a specific purpose. So this bill does talk about a money matter, which is imposition of tax, but it talks about some non-money matters as well. It talks about creating a body. Who is going to be the chairperson of this body? Who is going to be the member of this body? What are their qualifications? How can they be removed? What will happen to the data which this body may have about, let's say, those contractors who are making these roads? What about their data? Is that data safe or not? Can we share this data with others or not? Who will do the audit of whatever cess has been generated? That means this bill, which talks about a money matter, plus something else as well, plus non-money matter as well, such a bill is a financial bill. For example, CAMPA, Compensatory Afforestation Management Program, according to which, if there is a forest, let's say you have to construct a factory in a particular place, there may be flora involved, trees are there, you have to cut down these trees. Clear? You have to cut down these trees. That's how you can construct a factory, an industry. But it is an obligation on you that you have to compensate for this. Compensate how? You have to construct, you have to plant more trees at some other location, or you have to pay money. This money will be kept by the government. This is a financial bill. So when this CAMPA was passed by the parliament, it is a financial bill because it does talk about money matter, which means you have to pay money, but it talks about something else as well. It talks about compensatory afforestation. It talks about conditions that you have to satisfy. How, when can you fell trees and make industries and factories? It talks about money matters plus non-money matters as well. Any bill which is a combination of money matter and a non-money matter is a financial bill. But in financial bill, the Rajya Sabha has an equal role to play. It can reject a financial bill. It can amend a financial bill. It may not act on a financial bill for 6 months. And in case of a deadlock, there is a joint sitting of both the houses. When Aadhaar was introduced, it was introduced as a money bill. And Constitution says the certificate of speaker is final and binding. What does that mean? When Lok Sabha passes a money bill, this bill is to be sent to Rajya Sabha. Attached to this bill will be a certificate of the speaker that, hey Rajya Sabha, this bill is a money bill, which means you have an inferior role here. You can't reject this bill, you can't amend this bill, you can make recommendations, and at the expiry of 14 days, if you don't act on this bill, the bill shall be deemed to have been passed by both houses of the Parliament. Constitution itself says this certificate of the Speaker is final and binding. Which basically means if you want to tell me the definition of a money bill, I can say a bill is a money bill if it is certified as a money bill by the Speaker. And no power can question this certificate of money bill issued by the Speaker. No power. Why? Because this is mentioned in the Constitution. When Aadhaar was introduced in the Lok Sabha, it was introduced as a money bill. When it was introduced as a money bill, there were a lot of protests by the opposition, by others, saying this is not a money bill. Why? Because Aadhaar, yes, it talks about withdrawal of money out of Consolidated Fund of India. What does Aadhaar basically say? Aadhaar basically talks about benefits. What are these benefits? If we have to give LPG subsidy, kerosene subsidy, old age pension, scholarship money, that money will be deposited into the bank account of the beneficiary, and this bank account will be linked with Aadhaar. Clear? Since Aadhaar is unique, there will be no leakage, there will be no duplication. Because previously what would happen? Rajiv Gandhi gave a famous statement or an infamous statement wherein he said if we give 1 rupee to the state, only 15 paisa reaches the state, reaches the beneficiaries. 85 paisa is pocketed by the middleman. What used to happen is that if the state has to provide old age pension to the people, to the beneficiaries, here is the state. State has to give benefits. Benefits, let's say pension, to the beneficiary. Two problems were plaguing this system. One was leakage. The other was duplication. What is leakage? This benefit was given in the form of a middleman. Who is a middleman? Basically an officer. Government officer, for example. Now, central government is giving 100 crore to the state government that you have to give this 100 crore to your beneficiaries, to old age people. Above the age of 60, we will give them benefit. Old age pension, 500 rupees a month. State will say, we will give it to the district authorities. Now, the district authorities in its district has to distribute this money. Let's say 50 crores are to be distributed. What exactly happens is that if there are 100 beneficiaries, these beneficiaries are told, we will not give you 500, we will give you only 100 rupees instead of 500. So I, as a government officer, will go and visit this old lady and tell her, here is your pension, 100 rupee. But sir, I read that I'm entitled to 500 rupee. Take this 100 rupee, otherwise I won't even give you 100 rupees. This old age woman would say, okay, give me 100 rupees. What will happen to the remaining 400 will be pocketed. 200 I will keep, 100 I will give to my superior, 100 he will give to the politician. So there was leakage in the system. And there was also duplication. If there were only 100 beneficiaries, I would create 200 ghosts. There are only 100 beneficiaries in my district. Only those who are above the age of 60. I also take the record and I say all the 200 others who are right now dead, we will lift them from the grave and we will make them beneficiaries. Although they are dead, they are not entitled. But on paper, I say these are alive and I have to give them money as well. So 500 for these 200 ghosts as well. And I deposit this money in my pocket. A part of it I give to my superior. A part of it I give to the politician. Everybody is happy. Leakage and duplication. Dr. Manmohan Singh, an economist prime minister, known for his liberalization reforms of 1991 as the finance minister, he said, let's have Aadhaar. What Aadhaar is, it's a unique identification number, a unique 12-digit identification number. What makes Aadhaar unique is we give fingerprints, we give our iris scan as well, which means there is a unique identity for every individual, and this will be linked to the bank account as well. If these 200 ghosts, they can't have Aadhaar, how can you give them money? If we will remove this middleman by depositing money directly into the bank account of this beneficiary, that means this beneficiary will get 500 instead of 100. So we have removed middlemen, we have removed the ghosts as well. That is what Dr. Manmohan Singh said. Initially, it would be a DCT, direct cash transfer. But then somebody told him that cash looks like a bribe. Call it DBT, direct benefit transfer. I said, okay. There was one political party which opposed this, and that party was the BJP. Mr. Modi was the chief minister of Gujarat. He said, this Aadhaar we will not allow. What is DBT? What is DCT? Mitron. But then when Mr. Modi came to power, Aadhaar was passed into a law. Because previously it was just a government resolution. The government issued an order, direct benefit transfer started. The government issued an order, unique identification authority of India was created through a government order, through a government resolution. So this unique identification authority of India, which is responsible for rolling out this Aadhaar, this unique identification authority of India, it was only a extra constitutional, non-statutory body. It was neither mentioned in the constitution, nor was it created by the law passed by the parliament. It was created by a government resolution. When Mr. Modi came to power, Mr. Modi said, Mitro, let's pass Aadhaar as a law. This time Congress was opposing. It violates our privacy. But this is your baby. Now it violates privacy. And at that time, the government did not have the majority in Rajya Sabha. And at that time, we saw land acquisition bill was stalled by Rajya Sabha 4 times. There was another bill which was the legacy of the Congress, the UPA government. Land acquisition became difficult. The state acquiring land from the private players became difficult. Private companies acquiring land became difficult. Why? Because you needed consent. What was that consent? If this is the land in an urban area, you have to pay compensation to its owners, which is 2 times the market rate. If this is the land in the rural area, you have to pay compensation to their owners 4 times the market rate. If this is the land to be acquired for private purpose, for example, Adani needs a land, Ambani needs a land, then this land, let's say, is spread across 100 acres. And there may be 200 owners of this land. 80% should give the consent. 80% of the landowners should give the consent. Then Mr. Adani can acquire this land. Otherwise, no. If this is the land meant for government purpose, then 70% of the owners should give the consent. Mr. Modi said that this creates a difficult atmosphere for our industries, for our capitalists. We need to tweak this. We need to remove the consent clause. We need to remove the market price. But since government did not have the majority in Rajya Sabha, this land acquisition amendment bill could not be passed. And the government feared that Aadhaar may also not be passed. Mr. Arun Jaitley was the finance minister. He hit upon an idea. He said this Aadhaar is introduced as a money bill. When it was introduced in Lok Sabha on the prior recommendations of the president as a money bill, it was passed by Lok Sabha by simple majority. It was now certified by the speaker to be a money bill, then sent to Rajya Sabha. And Rajya Sabha also, even if it did not act on this for 14 days, money bill was passed, Aadhaar was passed. Mr. Jaitley was asked, how did you do it? He said, the speaker's decision is final. We believe in separation of powers. In separation of powers, judiciary cannot interfere with the proceedings of the parliament. If parliament has decided that Aadhaar is a money bill, it is a money bill. If the speaker has decided it's a money bill, it is a money bill. Because the constitution itself says that the certificate of the speaker shall be final and binding. Matter reached the court. Jairam Ramesh approached the court saying Aadhaar should not have been a money bill. Government said, no, you can't even challenge this in the court of law, because how can you challenge the decision of the speaker, which the constitution says is final and binding? Court said, no, we can. Because what is judicial review? It's part of the basic structure of the constitution. Mr. Jaitley was asked, how do you justify Aadhaar as a money bill? Because this bill, Aadhaar, it not only talks about withdrawal of money from Consolidated Fund of India to provide benefits, it also talks about creating a unique identification authority of India. What is the composition of this body? Who is going to be the chairperson? Who is going to be the member? What are going to be their qualifications? What is going to be their removal process? How the data that you will capture, whether this data can be shared with the court or not, whether this data can be shared with the private players or not. This bill, Aadhaar, it talks about money matter plus non-money matter as well. So this Aadhaar, in effect, should have been a financial bill. How can you say this Aadhaar is a money bill? Mr. Jaitley said, look at Article 110 of the Constitution. So what is Article 110? A bill shall be deemed as a money bill if it contains only provisions dealing with all or any of the following matters. One such matter is appropriation of money from Consolidated Fund of India. So for this Aadhaar, which basically means we have to provide benefits to the people, money will come from Consolidated Fund of India. That is why it is Aadhaar. That is why it is money bill. But Mr. Jaitley was asked, but it also talks about non-money matters. Said, no, it does not talk about non-money matter. It talks about any matter which is incidental to the above matter. What do you mean by that? To withdraw money from Consolidated Fund of India, we need to take care of the incidental matters as well. What are these incidental matters? How do I see whether this money is reaching the beneficiary or not? For that, I need to create unique identification authority of India. For that, I need to create an Aadhaar number. How do I ensure that this money is indeed reaching the beneficiary? I have to prevent leakage. I have to prevent duplication. For that, I need Aadhaar. So this Aadhaar number, this unique identification number, is basically a matter incidental to the withdrawal of money from Consolidated Fund of India. So this is not a separate matter. This is related to the withdrawal of money from Consolidated Fund of India. Any matter which is related to withdrawal of money from Consolidated Fund of India is a money bill. The Supreme Court agreed with the government and Aadhaar as a money bill was allowed. But then a review petition was filed. This judgment of the court was reviewed. But this matter is right now pending. We'll have to wait and watch what the Supreme Court will say on this matter. But one thing is clear. Supreme Court can do anything. What is Supreme Court? Final interpreter of the Constitution. Even if the Constitution says that the certificate of the Speaker shall be final and binding in deciding a money bill, this is explicitly mentioned in the Constitution. Supreme Court says no, judicial review is part of the basic structure. Some say this is judicial overreach. How can judiciary enter into the proceedings of the parliament? You stay away from this. This is the proceedings of the parliament. This is the privilege of the parliament, that judiciary cannot interfere in the proceedings of the parliament. Others say no. When there is blatant violation of constitution, Supreme Court must interfere in upholding the spirit of the constitution. Because if this is allowed, then by that logic, any bill is a money bill. Any bill is a money bill. How can we say any bill is a money bill? For example, we have to appoint the CVC, or let's say we have to appoint the Lokpal. For that, there is a committee. Committee consists of Prime Minister, Chief Justice of India, Leader of the Opposition. What if tomorrow the Parliament, the government wants that we will remove Leader of Opposition, we will remove the Chief Justice from the selection process. We will only have the Prime Minister and Home Minister. But government does not have the majority in Rajya Sabha. What the government will do, introduce a money clause here, saying we will have to withdraw money from Consolidated Fund of India to pay salary to CVC, to pay salary to Lokpal. Since this is withdrawal of money from Consolidated Fund of India, this is a money bill. By that logic, any bill, just to bypass Rajya Sabha, you have to just introduce one clause, withdrawal of money from Consolidated Fund of India. Such a bill can become a money bill. But Constitution is clear. Only those bills are money bills which deals with only these matters. This term only makes it clear that only if these matters are there, then it is a money bill. Anything else makes it a financial bill. Anything else would make it an ordinary bill, not a money bill. But to recap, long story short, what is a money bill? A bill is a money bill if it deals with money matters. Only those money matters which are mentioned under Article 110. For example, related to the taxes, related to the withdrawal of money from Consolidated Fund of India. If you want to make any expenditure as expenditure charged, such a bill is also a money bill. But money bill can be introduced only in Lok Sabha with the prior approval of the president. It requires simple majority in Lok Sabha. If it doesn't get simple majority, the government has to resign. If it gets simple majority, Rajya Sabha has a limited role. It cannot reject a money bill. It cannot amend a money bill. It can make recommendations. If these recommendations are acceptable to Lok Sabha, the bill is passed. If it is not, even then the bill is passed. Or if Rajya Sabha decides not to act on this bill for 14 days, at the expiry of the 14-day period, we shall say that this money bill has been passed by both houses of the parliament. Then a bill which deals with money matters plus non-money matters as well. Some money matters mentioned under Article 110 plus something else as well, plus some non-money matters as well. Such a bill is a financial bill. And in financial bill, Rajya Sabha has an equal role, almost equal role as compared to Lok Sabha. It's only that financial bill also can be introduced only in Lok Sabha with the prior approval of the president, but after that it has equal role with Rajya Sabha. That is a financial bill. Any questions? Let me know. Does president have pocket veto on money bill? No. Sir, government withdrawal from consolidated fund once in a year via budget or can withdraw many times? Anytime it needs money, you just need parliamentary approval. Money bill will be passed. You can withdraw money from Consolidated Fund of India. Sir, if IS officer resigned from his post and joined any political party, then this will be against the code of conduct? No. Why? You have resigned. You can join any political party, and we have seen politicians, we have seen bureaucrats joining political parties later on. Yashwant Sinha was a politician, was a bureaucrat. Mr. Subramaniam Jaishankar was a diplomat. Mr. Kejriwal has resigned from IRS and joined politics. And there have been numerous examples. Miss Meera Kumar, who was the Speaker of the Lok Sabha, she was an IFS officer. Yesterday, Odisha IS officer joined. He did not join the political party as yet. He is not part of the BJD yet. But he may join. He is considered to be the next chief minister of Odisha, despite the fact that he is not from Odisha. So doesn't passing the adjournment motion lead to the resignation of the government? That leads to censure of the government, and we will discuss that today. Once the salary is fixed, then you can't stop it. It is charged on the Consolidated Fund of India, like an auto debit facility. Without further parliamentary approval, the money is withdrawn and given as salary. Bill introduced by President only on the advice of the Prime Minister and Council of Ministers? Yes. Now let's look at what is an ordinance. Under Article 123, related to President, Article 213, related to the Governor. When either of the two houses or both houses of the Parliament are not in session, the President may promulgate an ordinance on all the items on which Parliament has the power to make laws. Number one, Parliament is not always in session. But we need a law. What do? COVID-19 pandemic, lockdown, everything shut. But one thing continued: the abuse of our doctors, the abuse of the paramedical staff, the abuse and torture of our nurses. Inside the hospital, patients, their attendants, they fight with the doctors, with the nurses. We somehow needed to prevent this. How can we prevent this? By passing a law to increase the punishment of those who would attack the doctors and the paramedical staff, to give protection to the doctors. How do we do that? For that, we need a law. But we can't have a law. Why? Because we can't have parliament in session. Why? Because there is lockdown. In such a situation, what do? We can resort to ordinance. Number one. Number two, lawmaking is a time-consuming business. Time-consuming in a sense, first you introduce the bill, you mention the statement of objects and reasons. What is the reason for this bill? What is the objective of this bill? What am I trying to achieve? Then this bill will be published in the government gazette. Then there will be second reading of the bill. Then there will be third reading of the bill. Then the bill will go to the other house. It will go through various stages. Then it will go to the president. Then president will sign. It will become an act. It will be notified. Then we will apply this law. So time consuming business. What if we need a law now? In 1 day, in 2 days. If we delay, it's going to have huge ramifications on us. What do we do in this situation? We resort to ordinance. What is this ordinance? Basically, Parliament has the power to make a law. Lawmaking is the job of the Parliament. Instead, for some temporary period, we will give this power to the President that you pass this law. And that law is what we call ordinance. But this is not the personal satisfaction of the President. President cannot issue ordinance, promulgate ordinance on his own. It's basically on the advice of the Prime Minister and Council of Ministers. Because if we need a law to prevent the abuse of the doctors, to increase the punishment for those who abuse the doctors, to give protection to the doctors, for that we need to have a bill. Who prepares this bill? This bill is basically prepared by the government. Union Cabinet meets, they prepare this bill, and then this bill is sent to the Parliament. Parliament approves it and then sent to the President for signature. Once this bill is prepared by the Cabinet, instead of sending this bill to the Parliament, we send this bill to the President. The dear President, because of these conditions, please promulgate an ordinance. So the same bill will now be part of an ordinance, will now be a law. But this time, this is not the law passed by the Parliament. This is the ordinance promulgated by the President on the advice of the Prime Minister and his Council of Ministers. Because we can't wait for Parliament to convene. But this ordinance if it was promulgated today, it will continue. Now Lok Sabha has been convened. It will continue. Now Rajya Sabha has been convened on this date. That means on this date, both Lok Sabha as well as Rajya Sabha, they have been convened. Now this ordinance will continue for 6 more weeks. Why? Because you promulgated an ordinance when Parliament was not in session. Now here both Lok Sabha as well as Rajya Sabha is now in session. Now what you need to do, you need to replace this ordinance with the bill. Get this bill passed by the Parliament within 2 weeks. If you can't get this bill passed by the Parliament within 2 weeks, this ordinance will lapse. That means this ordinance is of temporary character. And this is the same power given to governor as well. When Legislative Assembly is not in session, what the governor can do, he can promulgate an ordinance on the advice of the Chief Minister and his Council of Ministers. On what items can the governor promulgate an ordinance? On all items on which the state legislature has the power to make laws. On what items can President promulgate the ordinance? On all items on which Parliament has the power to make laws. And which are these items on which Parliament has the power to make laws? That means any item in union list, any item in concurrent list. That means ordinance can be promulgated on citizenship, on extradition, on banking, on insurance, on marriage and divorce, on criminal procedure, on civil procedure. On all these items on which Parliament has the power to make law, President can promulgate an ordinance on the advice of the Council of Ministers. Can it be used to amend the Constitution? Because if ordinance can be promulgated on all those items on which power is with the Parliament to make law, does Parliament have the power to amend the Constitution? Yes. Does that mean by the same logic, ordinance can be promulgated to amend the Constitution? Say yes or no. Majority says no. Very few say yes. Can it be used to amend the constitution? The answer is a big no. Why? Article 13. The state cannot make any law to modify or abridge fundamental rights, which means to make changes to the constitution. And what is this law? Law means act, rule, regulation, notification, bylaw, custom, usage, ordinance. That means even using an ordinance, you cannot amend the constitution. Constitution can be amended only by using Article 368, not through the route of an ordinance. But we say when either one house or both the houses are not in session. Let's say this is Lok Sabha, this is Rajya Sabha. If both are in session, can the president promulgate an ordinance? No. If Lok Sabha is in session, the Rajya Sabha is not, can ordinance be promulgated? Yes. If Lok Sabha is not in session, Rajya Sabha is in session, can ordinance be promulgated? Yes. If none of these two houses are in session, can ordinance be promulgated? Yes. But Cooper case and various other cases, what the Supreme Court has said, there will be judicial review. On the grounds of mala fide. What does that mean? If ordinance is promulgated today, when either one or both houses of the parliament are not in session, what the president can do? President can promulgate an ordinance on all items on which power is with the parliament to make law, on the advice of Prime Minister and his Council of Ministers. When this ordinance is promulgated, can judiciary challenge this? Yes. On the grounds of mala fide. That means there was no need to promulgate this ordinance. There was no hurry in promulgating this ordinance. There was no justification in promulgating this ordinance. The intention of the president is bad in promulgating this ordinance. If that's the case, then this ordinance will be struck down by the court. But this ordinance is of a temporary character. Temporary character in the sense, if right now you promulgate this ordinance will continue. But here, if Lok Sabha as well as Rajya Sabha are now convened again, if Lok Sabha is convened today, after 5 days Rajya Sabha is convened, or if Rajya Sabha is convened today, after 5 days Lok Sabha is convened, then on this date, when both Lok Sabha as well as Rajya Sabha were in session, from this date, this ordinance will continue for 6 more weeks. Within these 6 weeks, this ordinance is to be replaced with bill. Bill is to be presented to the parliament. And the minister who will introduce this bill will have to explain the reason to bring ordinance. What was the reason in bringing this ordinance? Why you could not wait for parliament to convene? If both houses of the parliament approve this bill, then this bill will replace the ordinance. This bill becomes an act. It is this act which will continue. If within 6 weeks, both the houses of the parliament, they do not approve this ordinance will lapse. This ordinance will lapse otherwise. So now, if I were to ask you, what is the maximum validity of an ordinance? Can you tell me what is the maximum validity of an ordinance? 7.5 months. Why? Because Parliament must meet as often as possible, but in such a manner that the time gap between the first and the second session should not be more than 6 months. That means within 6 months, Parliament has to be convened. And once it is convened after 6 months, this ordinance can continue for 6 more weeks. That means the maximum validity of an ordinance is 6 months plus 6 weeks. And there will be judicial review. But something else has happened. There have been instances, now listen to me carefully. Ordinances promulgated today, this ordinance has to be replaced by the bill, and this bill should be passed by the legislature. If it is not passed, ordinance lapses. Ordinances promulgated by the governor, the government of the day does not introduce a bill in the legislature to replace the ordinance, which basically means the government allows this ordinance to lapse. Once it lapses, this session of the legislature is also over. Governor promulgates the same ordinance again. It continues. Now, within 6 months, legislature is to be convened again. Bill to replace this ordinance is not introduced in legislature, which means this ordinance will lapse. Once the ordinance lapse, then after some time, legislature also session is over. When session is over, governor promulgates or re-promulgates the same ordinance again. And this cycle, this vicious cycle continues. And this happened in Bihar. Vadwa case. Ordinance was re-promulgated. Ordinance was promulgated, lapsed, re-promulgated, lapsed, re-promulgated, lapsed, re-promulgated, lapsed, and this continued for 256 times. Matter went to the court. Krishna Kumar versus State of Bihar. Supreme Court said, re-promulgating an ordinance without tabling it on the floor of legislature is committing fraud on the Constitution. If you are promulgating an ordinance but not placing this ordinance in the legislature, allowing it to lapse, then re-promulgating the same ordinance, you're bypassing the legislature. That means you want to rule through ordinance, not through law. This goes against the spirit of the Constitution. You are committing fraud on the Constitution. For example, the 3 farm laws. Basically, they were introduced as 3 farm ordinances. These 3 farm ordinances were passed. And once Parliament was convened, the 3 farm bills replaced the ordinance. Then these 3 farm bills were passed by the Parliament. And then these 3 farm bills became the laws. But it's another matter that these laws were later repealed by the Parliament as well. So that's a separate matter. But ordinances, when both houses of the Parliament are not in session, or either of the 2 houses of the Parliament are not in session, the President can promulgate an ordinance. But if you are re-promulgating an ordinance without tabling it on the floor of the Parliament, you are committing fraud of the Constitution. But this is a half-baked solution. It's a welcome decision, but it is not such a good decision. Why? Because you should have basically banned repromulgation. Yes, we understand that there may be a situation, there may be conditions where we need a law immediately. Otherwise, we will have to face drastic impact of that. For that, ordinance should be promulgated, yes, but it should be a one-time exercise. If on the same ordinance you introduced a bill which was not allowed by the Parliament, on the same matter, you should not be allowed to repromulgate the ordinance. The Supreme Court has only said that you promulgate an ordinance. If you have to repromulgate, you have to introduce this bill in the Parliament, in the legislature. Even if this bill is not passed, you can still repromulgate the ordinance on the same subject. This should not be allowed. Repromulgation on the same subject, which is disallowed by the Parliament, should not be allowed. That should have been the decision of the court. And that can be the reform that you can suggest in your answers. Repromulgation should not be allowed after both houses of the Parliament have rejected an ordinance. After the Parliament has not approved that ordinance on the same subject, President should not be allowed to promulgate the ordinance again. So what is an ordinance? Under Article 123, President has the power to promulgate an ordinance. Under Article 213, Governor has the power to promulgate an ordinance. When? When either one or both houses of the Parliament are not in session. When either Legislative Assembly or Legislative Council or both the houses are not in session. On what items can this ordinance be promulgated? On all items on which power is with the Parliament to make laws by the President. On all items on which the state legislature has the power to make laws by the Governor. Which basically means Governor can promulgate an ordinance on law and order, land, agriculture, gambling, so on and so forth. But this ordinance is for a temporary period. Once both houses of the Parliament are convened again, then within 6 weeks, you have to get this bill, replace the ordinance, and get this bill passed in the Parliament. If it is not passed, ultimately the ordinance lapses. But whatever decision was taken during that phase, when ordinance was promulgated, those actions cannot be nullified. For example, if under Land Acquisition Act, if an ordinance was promulgated that this land is to be acquired under this ordinance, later on this land acquisition ordinance lapsed, what will happen to the land which has already been acquired? It will remain acquired. Why? Because during the time when this land was acquired, ordinance was a law. It was in force. Later, if this ordinance lapses, what will happen to the actions taken under that ordinance? Those actions continue. Which means if such is the danger of an ordinance, you have to prevent its misuse. And that is why judicial review is very important. And you can challenge an ordinance in the Supreme Court, in the High Court, if you can convince the court that there was no need to issue this ordinance, promulgate this ordinance. The intention of the government is bad, malified intention, bad intention. On this ground, you can challenge the decision of the promulgation of this ordinance. But this ordinance, can it be repromulgated? Yes. But every time you repromulgate it, you have to introduce a bill to replace this ordinance. The Supreme Court has said repromulgating an ordinance without tabling the bill on the floor of the Parliament is fraud on the Constitution. But it stops there. It should have continued. Continued in the sense, it should have said repromulgating an ordinance on the same subject which was rejected by the Parliament. That cannot continue. That should not continue. That would have been to prevent the misuse, overuse, abuse, hyperuse of Article 123 of the Constitution. That is an ordinance. How Supreme Court verdict is reversed using ordinance in Delhi case in Parliament. We will discuss that in Union Territory. When we will discuss Delhi's example, we will discuss that judgment. So judgment was given by the court that the real government in Delhi is the government of Mr. Kejriwal. Few days later, the president promulgated an ordinance saying the government is of lieutenant governor, not the chief minister. Why? Because at that time, Parliament was not in session. Now, this ordinance has been challenged. Let's see what the court will have to say on that matter. Can national emergency be declared by an ordinance? Logic and common sense. These must go hand in hand. You issue an ordinance in absence of a law. That means you promulgate an ordinance if you can't enact a law right now. That's what you do. To impose national emergency, you don't need a law. You just need the advice of the cabinet. Cabinet will advise the president. President will impose national emergency. Where is the need for a law? So budget is a financial bill or money bill? Budget is a money bill, which we will discuss. Prachi, what's your question? Sir, please answer me. When these 25 classes are finished, will these classes be still available on the Byjus app? Yes. If Rajya Sabha is always in session, then ordinance can be voted for Rajya Sabha. So why wait for 6 weeks? Ashutosh, Rajya Sabha is the permanent house of Indian Parliament. But that does not mean that Rajya Sabha is working 365 days. For Rajya Sabha also and Lok Sabha also, there are 3 sessions of the Parliament. That means between monsoon session and the winter session, Rajya Sabha also is not functioning. Between budget session and the monsoon session, Rajya Sabha is not functioning. So how can Rajya Sabha give approval? How the budget is presented, how the budget is enacted, what are the various motions, resolutions, how Parliament exercises control over the executive. And we will raise $1 billion question: is Parliament functioning or not? And how can we make Parliament function better? What are the innovative steps that we can take to make Parliament a vibrant, thriving institution? That we will discuss tomorrow. Abolished by enacting or passing a new law. You pass a law, you pass a bill to create an institution, or you pass a bill to implement something. You'll have to pass the bill again to redo it, undo it. For example, a law was passed to create National Commission for Women. A bill should be created, bill should be passed to abolish this institution. The decision of the Speaker on money bill is final and binding. This is correct statement because this is mentioned in the Constitution. Verdict. Basically, to undo what Supreme Court did, a law was passed. But since Parliament was not in session, an ordinance was promulgated. And I gave you the example of the Shabano verdict. When Shabano verdict was given by the court, the Parliament enacted a law, Muslim Women Protection of Rights on Divorce Act 1986. So you can always undo the verdict of the court by passing a law. But for that, you have to nullify the grounds on the basis of which the judgment was given, which is a very difficult terrain, which is presented by the cabinet to the president, that please promulgate this bill as an ordinance. Now, once this ordinance continues, now Parliament is in session. Same bill will now be presented before the Parliament. You approve this bill so that this bill becomes a law. and that ordinance lapses. And why don't the Parliament pass the bill if ultimately the decision is of Council of Ministers and Prime Minister only? My dear, Parliament alone would have passed the bill. But right now, Parliament is not in session. But we need this bill urgently. We need this law urgently. That's why instead of waiting for the Parliament to be convened, we ask the President promulgate the ordinance. So that once Parliament is convened, we will ask Parliament to pass the law. And your ordinance will lapse. Because this is of temporary character. In session, money bill can be introduced via ordinance. Discuss budget. Order to apply Indian Constitution to Jammu and Kashmir. Ordinance is different. Ordinance is basically a law of temporary character which is promulgated by the President, which means by the executive, since Parliament is not in session. So can, because governor also, state legislature also has the power to make a law on concurrent list. Then President would be removed from his office. And that process is what we call impeachment. If there is no President, Vice President acts as the President. So now this person is the President. And this person will promulgate the ordinance. He will have the same powers as that of the President. He will also stay at the Rashtrapati Bhavan. He will also get the same salary as that of the President. Because you are now acting as the President of India. Kyoto Holohan versus Zachilhu 1992. Then there is another Jairam Ramesh versus Union of India. In all these cases, Supreme Court has said Speaker's decision is subject to judicial review. There have been numerous other cases as well. Swami Prasad Maurya and others, R. Balaji case and others. So many judgments. Shiv Sena case recently. Asking that after promulgation of ordinance, when the Parliament sits for the session, then why don't the Parliament pass the ordinance into a bill if the Prime Minister and Council of Ministers only advise the President to promulgate the ordinance? I think you are getting slightly confused. Let's say we want to increase the punishment of those who attack the doctors. For that, we need a law. We basically need to amend the Epidemics Act, for example. To amend Epidemics Act, we need to pass a bill in the Parliament. Once this bill is passed by both houses of the Parliament, it becomes a law. But now Parliament is not in session. So this bill, instead of sending to the Parliament, we send to the President. That, dear President, please promulgate this into a law. We can't wait for the Parliament to turn this into a law. You turn it into a law, we will call it ordinance. Fine? Once this ordinance continues, then Parliament comes into session. Then the minister presents a bill inside the Parliament, which is basically bill replacing this ordinance, which is basically the bill, the original bill, which was presented to the President. You may have made some changes here and there, that's also okay. Now this bill is passed by the Parliament. And now this bill is now a law. And this law will continue. So that ordinance disappears, lapses. Bye. Goodbye.